travel day, so
Oh.
we're expecting.
Oh, and you have to give them a minute.
Ready to go? Okay, good morning. We'll try that
Here we
again.
go. See
We are
more.
expecting more people to show up because there's some difficulties with travel. But welcome to all of you. Really glad to see you. Mimi, I'm going to turn to you to do the roll call.
Okay. Justice Edmond,
Here.
Toby Rothschild, Joyce Raby,
Here.
Andrew Ruda, Simon Bomey,
Question mute.
Tara Bird,
Here.
Judge Wendy Chang, Abhijit Shavan,
Here.
Jean Clausen,
Here.
Johan Droshagen,
Present.
Margie Estrada, Lori Gonzalez,
Here.
Bridget Grammy,
Here.
Andrew Kuchera,
Present.
Joanna Mendoza, Kevin Moore, Heather Morse, Daniel Rice, Alan Rodriguez,
Here.
Daniel Rubens, Mark Tuft, and Angelina Valverde, and Joshua Walker. Thank you.
Okay. Thank you very much, Mimi. We are now going to call for public comment. Is there anybody who wishes to be heard about any of the matters on our agenda? All right, hearing none. I don't have much of a chair's report. I'm going to turn to Randy to fill us in on sort of where we are at this point and where we're headed. So Randy, you want to take over?
We did have one written comment that came in through the mail. It was a letter from Court Buddy to the task force. I'm thinking maybe Lori, did you want to say something about the letter in case some people didn't catch? It's a 21-page letter, so maybe not everybody was able to read every word.
And by the way, there are copies here.
Yes.
Extra copies if you didn't see it and you want to take a copy.
And it's posted online with the agenda materials too.
I think it did have some pretty interesting data. Court Buddy definitely works within the current regulations to help meet the needs of, I think they have a pretty heavy focus on meeting the needs of rural clients by instantly matching clients with lawyers on their platform. And so they have collected some interesting data on how that's working. But again, they operate very strictly within the rules. So I'd love to see what they can do outside of if those rules were relaxed and allowed them to do some other things. So definitely worth the read. I appreciated that they were, they're working in, I hate saying this because I didn't check, a ton of states. I don't know exactly how many states. But they have definitely built out a matching idea where the consumer sets the pricing model. So the consumer actually says what they need done and how much they're willing to pay for it. And then it matches them with lawyers who've already agreed to work on those type of things within that same fee schedule. So really interesting idea. They were in our speaker last month, one of her when she gave her list of people who are doing interesting things, they're actually one of those. Won a ton of awards, definitely worth a read and to hear. And their main focus was that they really feel that even though they've had some great success working within the rules, relaxing these rules, especially around fee sharing and some advertising rules, would really go a long way to letting them provide even more services to more people. So I hope that was the crux of it.
Thank you.
Thank you, Lori. I just wanted to take a moment to talk about three things. The first thing is not this past Monday, but the Monday before, one of the subcommittees, the ABS MDB subcommittee, met, and we noticed that meeting in order for them to take action on their recommendations that they're going to bring forward this afternoon. And it was a very productive meeting. They met in person in San Francisco. They were able to work through a lot of things that they didn't have time to work through at the April meeting. And they are going to have a breakout session here. They're lacking leadership and a quorum, so they won't be taking action, but they've already taken action at that meeting on Monday, and those will be coming forward. The Rules Ethics Opinion Subcommittee actually has noticed the meeting for tomorrow. So they will be continuing on with their work on their recommendations. We might have some coming forward this afternoon, but definitely at the June meeting, with this extra meeting that they have set for tomorrow, which is going to be in person here in Los Angeles, they'll be ready to go with all of their recommendations, we imagine, at the June meeting. If any subcommittee, including these two that have already had in-between meetings, want to do so, please work with Lauren and Mimi to get that scheduled. We need 10 days in advance notice, and it doesn't have to be in person, as these meetings were held. One was held in San Francisco, Rules meeting subcommittee in LA here. You can do it completely by phone if that is more workable for schedules. You can do it by video conference if you want to come into the LA office and the San Francisco office and link it through our video conferencing system. We can do that as well. But if you want to pursue this, you might want to have the initial discussion in your subcommittee sessions today, just to figure out that is something you want to do. Maybe get some dates that you want staff to vet so that we can get it noticed and on the calendar so that you have that extra opportunity. It doesn't have to be a full day marathon like we have with our full task force meetings. It could be 2 hours, it could be 3 hours, whatever you want that would help advance your agenda. We're happy to facilitate and make happen. So I do encourage the subcommittees. One of the reasons why we had them form as independent entities is so that they can do just this. Regarding recommendations, we do anticipate, that's the second thing I want to talk about, that these will be coming forward this afternoon. And when they are presented, we do need the actual motion, but you're going to ask us to recommend that we present to the board and ask for authorization to distribute for public comment to be articulated, wordsmith exactly how you want it to be presented to the board. So that 1 or 2 sentences that is your recommendation should be memorialized as you vote on it at the subcommittee level. But in addition to that, we know that some of these things in isolation might be a little bit ambiguous. So in your subcommittees, if you could appoint a point person to give the longer version of it, to explain it, and in doing so, there are 2 things that would be really helpful to include in that explanation. One is how it ties into your section of the charter. So if you recall, we are divided into 3 subcommittees because there are enumerated 3 sections to the charter. And if you could refer back to the charter and say why this recommendation is responsive to that, that would be great, because then we know it is anchored to a specific issue that was put before us by the board. The second thing is, if you could give us a little bit of the flavor of the deliberative process at the subcommittee level. And so if you look at the agenda materials, you'll see that Andrew's subcommittee, ABS MDP, put up their recommendations, but then they gave us these 2 nice little Reader Digest version of their pros and cons. What do we think is good about this? Why is this going to advance the initiative of delivery of legal services through technology to those most in need? And what might be some of the challenges? What were the cons, per se? And so if you give us a little bit of that flavor, the pros and cons, then the task force, as we closely scrutinize the recommendation before we vote on it, can ask intelligent questions and be able to have an informed decision as we go forward. And something that has been sort of percolating up about these recommendations is the concern that they might be inconsistent or contradictory. And we had our earlier staff meeting with the State Bar CEO and with Donna, who's here with us this morning. And what we really are looking for at this stage of the game is not a full-blown report. Eventually we'll need that, and I've been hinting at that it should maybe look like the MJP report, because that was viewed as acceptable to meet the burden of persuasion for the court, and the court will also be looking at these recommendations, we think. And so we'll need that at some point, but what we need to go out for public comment is really just the articulated recommendations. And if the recommendations are well articulated and explained, then we're not going to need the fuller treatment of the report. And we also don't have to indicate necessarily a preference among recommendations. And so if you look at today's agenda, you'll see that on the Rules Ethics Committee Subcommittee, we have something that Professor Moore drafted up in terms of a possible strategy where we would amend our Rule 5.4 and provide an exception for sharing and partnering with non-lawyer individuals or entities. And that could be a way, standing alone, to answer the concerns of using technology to deliver legal services, that you modify that rule, you allow the non-lawyers and the lawyers to be co-owners, and you go forward. But you've seen other things in our materials as well. Complete new regulatory structures, even one that talks about maybe getting the federal government to take a lead in regulating, or some independent entity that would partner with the state bar in regulating. And these are taking a very different strategy. They're saying, apart from the lawyer rules and allowing lawyers and non-lawyers to partner to do this, we'd like to have a standalone new delivery system through individuals or organizations that have a possibly completely separate regulatory scheme. And we don't have to decide that this afternoon or at the next meeting. We can put out both regulatory reforms as a proposal, and we could seek public comment on both, because it could be we will get very good feedback on both to help us later decide if we want to favor one or the other. The other thing is, there is still a bit of a missing part on the recommendations in terms of the enforcement side of things, and the specification of some of the regulatory restraints that are going to be placed. And there are some different models for how you go about defining the regulatory standards. There's the sandbox we heard about last time. There's this ATILS approach that was presented in our materials this time. And so if your recommendation is being hung up because we can't decide how we're going to accomplish the accountability side of it, because it is a balanced equation that we're presenting, access but also public protection, then it's completely fair to say we believe that there ought to be some regulatory hooks, some enforcement remedies. We describe them in concept, that individuals of the non-lawyer might have to agree to conform their conduct to the standards of lawyers, or might be subject to being decertified if their entity or as an individual they're certified. That there is the concept of enforcement and accountability, but that the details should be done through a different methodology, that it should be risk-based regulation, sort of like the ATILS approach, that we should have some experimentation venue like a sandbox, but the recommendation shouldn't be hung up and going out for public comment because we haven't detailed that part of it. Let's get the recommendations out, and ultimately an implementation body is going to have to be convened to get into those details once there is perhaps a consensus by this group or the board as to what of the spectrum and menu of options we really want to put our emphasis on in proceeding. The last thing is, with regard to the recommendations, we want to stick with the ones that are the core to our charter, which is delivery of legal services through technology. I did notice that, and this is completely fine, that there's some recommendations that are sort of on the bubble. And so when we're talking about recommendations to authorize, for example, limited licensed legal technicians to be standalone companies or individuals that actually are licensed to provide law-related services or actual legal services, and it's not necessarily designed to be tied to any technological delivery system, that is something that's actually on the State Bar's strategic agenda. And Mimi can put it up on the screen right now, but the State Bar has a 5-year strategic plan. And one of the goals is that we are going to, is that the one, by 2020? No later than December 31st, 2020, explore options. There it is. So the board has on its radar, as a standalone objective with the goal of access, to look at paraprofessionals, independent licensees of some sort. And we could certainly say that in discussing the reforms that would focus on entities or individuals using technology, that the same model would translate well to these individuals. And we can absolutely have that as an ancillary or side recommendation or report. But if we're going to stay true to the anchor of our technology focus, then let's keep that in the forefront so that the public comment we get back is similarly focused on that. And this will come. It's definitely something that the board has targeted for 2020 at the latest to look at. And the fact that we concur with that exploration, that should be something, because we did hear loud and clear from Professor Sandifer at our last meeting that even in all of her research, she doesn't think that technology is a silver bullet single solution. She thinks there are other reforms are necessary to meet this access crisis. Of course, we can say that in a report and say that we think that that type of regulation is worthy of exploration. But when we come to voting on recommendations this afternoon, we'll probably start with the technology-based ones and go from there. And that's all I had to say about the consideration of recommendations this afternoon and next meeting. I think Bridget?
I don't know if this is working. Is it? Yeah. I just wanted to comment on that one, that last piece of it. I think it's hard because all of these regulatory issues really converge. And so when we're talking about triple LTs, for example, I think it's relevant to the technology piece in that maybe there are people working for technology companies who are not attorneys, but I think what we're trying to say is they should still be allowed to deliver legal services, and we should recommend some way in which they can be regulated. So I think that's how it comes up. I mean, I understand what you're saying, that we don't want to get too far afield, but I just wanted to point out that it's not completely separate.
No, it wouldn't be completely separate if you're talking about detailing who are the personnel in the registered or certified entity who would be participating, whether there's supervising lawyers or if there's paraprofessionals involved. I think that's completely fair to include it in the concept of the regulatory scheme. But if we start talking about who's going to license them, what are the qualifications to be certified, I think we might be going a little bit ahead of where the board is scheduled to look at this.
Any further questions or comments on that issue? Randy, you want to talk about the survey?
Yes, and so we did proceed, and thank you to the members, the task force who volunteered to look at survey questions, but we did meet twice with the group that was making a proposal for us to do a survey. We did get some cost structures in front of us. We did look at some possible questions, how we would pursue the survey. And we're at the point now in considering the survey where we're thinking that it might be a little bit late of the game, might be a little bit too rushed to actually do this. Ideally, if we were going to do a survey, we would have commissioned Professor Henderson as part of his legal landscape report to inform his legal landscape report with the original research that comes from that type of a survey. But we didn't at that point, and now we're trying to do it in a very hurried fashion right now at a pretty high price point, because in order to get the information we'd be looking at, in talking with our consultant that we were entertaining on doing the survey for us, they said we would be looking at oversampling in areas of rural and oversampling at 125% poverty level, and that for every oversample you get to make it statistically valid and relevant, the price tag really goes up. And the manner in which you have to do the branching of the questions also becomes even more complicated. And so we're up against the clock. We wouldn't be putting forth the best possible product probably with the shortened time to get the survey out. And there's actually a lot of data already that's been gathered by others who have surveyed this field. And we also have the opportunity to do, through the public comment process, directed outreach to get public opinion through that circumstance as well. And so at this stage, I don't know if Donna, if you want to say anything more, but we're thinking we're probably going to stand down on the pursuit of a survey. And it doesn't mean that after we submit our report in December, the final report, and the board says, well, we're very interested in the concept of say, the separate regulatory body that's going to be independent and certify entities to provide legal tech, that at that point the board might say, and now that we have something that has been informed by the work of ATILS and has gone through public comment, and we've sort of focused on that one, that wouldn't be a more precise way to survey the public, because now you have an idea that you really want them to respond to. So it doesn't mean we're never going to do a survey to facilitate the final decision on this. It just means that we're not going to try to rush it and fit it in right now.
Thanks, Randy. Yeah, I would just add, to the extent that we thought the survey would be beneficial at this point, that it would lead to results that would affect what our recommendations would be, then we certainly would have done it. So yes, it was a higher price tag than anticipated, but that was not going to stop us from doing it if we thought this was going to be effective. Randy and I were having conversations about the survey, and I said, so let's assume 85% of the people who respond to the survey say that they are absolutely supportive of having legal advice being given to them through technology, whether or not there's a lawyer involved at any point. Now let's assume only 25% respond that way. How does that change the recommendations of this group? And the answer was it really didn't. And so to the extent that the information that we're going to get back from the survey isn't really going to have a significant impact on the high-level recommendations that this group is going to be putting together, it just didn't seem like the best opportunity to do it. I also followed up with Professor Sandifer, and we talked a little bit about some of the questions that we might ask. And some of the things that we had put in there we're looking at the type of regulatory body. And she said, most of the public, they don't care. They don't know one from the other. Are you really going to accept their input on that, or say, oh, they just don't know? Will that really affect what you're doing? So she thought any of those questions were probably not going to be useful for us. I think Randy's point is a really good one, which is that we may come to a point where it makes sense to ask specific questions, in which case we can certainly launch a survey at that point. And also what we want to take some guidance from, if any of you are familiar with the invitations to public comment that the Judicial Council puts out, a few years ago they started adding a box at the end of the invitation for public comment that would say something like, in particular, we're interested in people responding to the following and providing specific information. And then they'll also say, and for courts, we also want you to provide this. So we thought using that as a model for a way to invite those in the technology industry to respond to certain specific questions, those in the general public and lawyers, might be a good way to get responses to defined questions that we have at the point we put this in the field.
Okay, any questions, comments about the survey or non-survey? All right, Randy, anything else? All right, we have an action item of the approval of the action summary from the last meeting, the April 8th, 2019 meeting. Is there a motion to approve? All right, it's been moved and seconded. Johan? Please.
All right, Andrew Ruda, Simon Boney, Tara Bird, Judge Wendy Chang.
Are we voting?
We're voting on approval of the action summary, what everyone keeps saying here. Sorry, this is real loud. Abhijit Sivan. Jean Clausen.
Yes.
Johan Drolshagen.
Yes.
Margie Estrada. Lori Gonzalez.
Yes.
Bridget Grammy.
Yes.
Andrew Kuchera.
Yes.
Joanna Mendoza. Kevin Moore. Heather Morris. Joyce Raby.
Yes.
Daniel Rice. Toby Rothschild.
Yes.
Alan Rodriguez.
Yes.
Daniel Rubens. Mark Tuft. Angelina Valverde. And Joshua Walker. Thank you.
Okay, we've got Allison Paul as the speaker. I've not seen Allison. Has anyone? Oh, great. I didn't know that either. And so, do we know if she's online?
Lauren's on the WebEx, but they haven't joined. I can't see them on the list of people on the side.
We have a special set for
10:45.
10:45. No, I know. Okay, so in order to been spending a few minutes here in the
Justice Edmund. While we're waiting, I'll just go through the schedule of the day, and then Mimi can tell us the rooms that we're going to have later on.
That'd be great. And then could you also walk through the schedule sort of in the big picture, where we go from here in
Sure.
terms of timing and when the public comment will go out? And just remind us all
I'll
sort
do
of
that
generally
first.
the schedule.
So I don't know if folks have this document, the small table with the schedule. Is there one we can project? Because I'll just refer to it. And so the next meeting, the full task force meeting, is June 28th. It'll be in San Francisco. That is essentially our meeting where we're going to begin focusing on the recommendations that are going to be included in the public comment report. What we're hoping is that even before that meeting, if there is an opportunity, if it fits in your schedules, that if your subcommittee is looking at needing extra time, that you'll schedule a meeting between that. And so I think I mentioned earlier, if you could touch base on that during your subcommittee sessions today, this calendar might be amended to include some subcommittee meeting between this meeting and June. After the June meeting, we would be going to the board to actually seek their authorization to put out our tentative recommendations for public comment. The board is meeting on July 12th, and hopefully we'll have representative of the task force to assist us in that presentation and asking the board to put out the recommendations for public comment. Again, you know, we wouldn't be looking to have the fully rendered report that we will have at the end in December, but we will be looking at having the organized presentation of recommendations, being able to explain what we mean, what our objective is with those recommendations, and what are some of the pros and cons, so that the board can wrap their arms around and get it done. Sorry?
Is that Board of Trustees meeting here in Los Angeles?
The July meeting is in Los Angeles.
Okay.
Well, the board will be asked two things. They'll be asked to put it out for a 60-day public comment period. It'll be posted on the State Bar website. And at that point, it'll be completely fair game for anybody to point to and outreach with. And so, particularly for the members of our task force who have extensive networks, maybe through social media, once the link is there for the tentative recommendations that are out for public comment, you're strongly encouraged to use all of your influence to get that out to assure the widest range of consideration. And some of the same Bagley-Keene restrictions would apply, so we don't want members of the task force commenting on each other's outreach, but definitely using your individual channels to do that would be welcome. It's not a complete substitute for what we've gotten through survey, but historically, anyone who's served on a State Bar committee and put anything out for public comment, even though the moniker is public comment, the comment we always get is usually just lawyer comment. And the State Bar staff is pretty good at rounding up the lawyer comment. Going to the Bar Association ethics committees and other bar leader contacts, the CLA now is the primary contact. We can certainly round up the lawyer comment during the 60 days, but we would be relying heavily on the others on the task force to try to get some non-lawyer comment. During the public comment period in August, we will have a task force meeting on August 9th in San Francisco and a public hearing on August 10th. And the public hearing on August 10th is in San Francisco because the ABA convention is going to be held in San Francisco, and the Association for Professional Responsibility Lawyers will be having a meeting in connection with the ABA meeting. And the group also has a very active, an access through technology group like ours, and we would be hoping that our public hearing would garner the attention of both April as well as other participants at the ABA level, other states that are looking at this who could help us by providing their input at our public hearing. And so that's tentatively scheduled for the afternoon of Saturday on August the 10th. And because it's not a meeting, we don't need a quorum of the members of the task force to launch it. But any member who is available, who might be attending the ABA convention for other reasons, is welcome to sit on the public hearing panel. So if you know already that you're interested in attending, let us know and we'll start setting that up. It is something that has to be outright approved by the board before we can make it official, but we will be asking that of the board in July. Put it out for 60-day public comment and to also authorize the August 10th public hearing. After the 60-day public comment period, our next meeting is going to be in Los Angeles on October 7th. That's going to be our first opportunity after the close of the public comment period to begin assessing the public comment we've received. Because we're going out with sort of a menu approach, we're not trying to restrict or harmonize our recommendations. We're going to throw everything out there and see what gets back. The downside of that is that afterwards, when we do have the public comment, we do have to individually assess all of those things and decide, are we going to give the board a menu approach? Are we going to try to harmonize our recommendations or prioritize them? And I think it was Mark Toft at the last meeting who said he hoped that we wouldn't try to necessarily exclude things, but if we saw some things are more promising in the short term, that you might even have proposals that might say, consider this first, but don't reject this, consider it next. And so there's lots of different ways you can go about it, but we will have to look at the public comment at our October meeting in Los Angeles so that by the time we get to our November 6th meeting in San Francisco, we're starting to revise those recommendations in response to the public comment. And still at that stage, we will not be wordsmithing actual changes to rules of professional conduct or statutory amendments to the UPL statutes. We're really still at a concept level, but we do have to re-wordsmith the actual recommendations to fit what we think is the changes that need to be made in response to the public comment. When we hit the December meeting, December 12th in San Francisco, and let me mention that none of these last three meetings are your typical Friday bar meeting. The October 7th is a Monday, the November 6th is a Wednesday, and then the December meeting, December 12th, is a Thursday. And the November and December meetings are back-to-back in San Francisco. So I just wanted to call that out. And the December meeting will largely be a meeting to finalize the reported recommendations that are going to the board that we will be voting at. So that is the macro game plan. And since we're not doing sort of the fully rendered report for the public comment period, we might have to have all that other aspects of the report finalized by that December meeting as well. Any questions on the big picture?
Thank you very much.
So we do have the schedule for today. 10:45, we have a special set presentation by Allison Paul of Montana Legal Services Association. Their group receives legal services grants specifically aimed at developing access through technology. She's going to tell us about something called askcarla.org. So that's coming in about 6 minutes. She will have until 11:30, or if we have more questions and answers, I'm sure we can go a little bit longer. But about 11:30, we will be breaking out into our subcommittee meetings. Mimi, do you know which rooms our folks are in?
In 2A will be UPLAI, and then in 2B will be ABS MDP, and the Rules and Ethics Opinion Committee will be in here.
So Rules, Ethics Committee will be in this main room, and we'll be the subcommittee that is being streamed. Okay. Lunch is about 12:30 to 1, and so each subcommittee can decide when they specifically want to break out, but it's in that time frame. You should grab your lunch. 1 to 2, we're going to continue with the subcommittee meetings. We're keeping the subcommittee together long enough so that you can flesh out your recommendations, designate your point persons to present them, etc., for the afternoon session of the full ATILS task force, which will begin at 2 o'clock. And so we will have 2.5 hours to discuss and vote upon any recommendations that we're bringing forward. And as I said earlier, the ABS MDP already voted theirs out at the in-between meeting on the prior Monday, and so we know we at least have those 5 that we're going to be taking up, but we have certainly enough time to talk about more. So in your subcommittees, whatever you can finalize for presenting, I encourage you to do that so we can make the most of our 2.5 hours we have in the afternoon.
So do we know if we've got Allison on the line?
Are we going to be seeing them or just hearing them? Okay. Can we take a 5-minute break then?
Sure. 5-minute break?
Just for them to consider.
Oh, these are the charters. Yeah. Yeah, I was wondering if they were in our materials. with Allison and this program in Montana. And so why don't you give us a little background?
Hi, Allison. This is Joyce. It's been a while since you and I have chatted. I hope you're doing well. Or not.
Or not.
I don't know what to say now, but I'll just keep going. I'm not going to repeat the material that was included in your agenda, but I did want to share with you a little bit about Montana Legal Services.
Can you hear us, Allison?
Is it better now? Is that so? Can anybody hear? Are we doing? I don't. All right.
Or maybe.
So we can hear one person, but very faintly hear anything else.
Do you hear me better now?
Yes.
I feel like the Verizon dude. Can you hear me now?
We're almost there with the slides.
Well, hi, Allison. This is Joyce. I'm going to do a little introduction. We've included in the materials your official sort of credentials and background, but I wanted to share with the group just briefly that Montana Legal Services has done a lot of work with technology over the course of at least the last 20 years that I'm aware of. In part because of the nature of the state of Montana. Those of you who may have been there realize there's pretty significant land mass, small populations, lots of rural and potentially physical barriers, mountains, canyons, and other things that tend to make it difficult for people to get to courthouses, identify services, and participate in those services. And one of the things I wanted to ask Allison and Angelina to share with us today is because they have a long history, they were one of the first states to implement using chat rooms to provide navigational assistance via the web on their public legal information website. They were one of the first states to experiment with video conferencing for courtroom appearances as well as for securing legal services. In addition to this new platform that they're talking about in terms of askcarla.org. And we're all really interested to know who Carla is and why we call it that. So I'm going to ask you specifically to answer that question. But I would also like you to give us a little context on, as you have adopted some of these technologies and implemented them, do you have a sense of, what success metrics did you use? What are the pros and cons? What is your just experience with technology generally about its ability to make a difference? I think this group in particular would be looking at what are some maybe positive consequences that came out of your experience as well as potential pitfalls. I think all of that experience and expertise might really inform the work that we're doing here. So Allison, I know, has been at Montana Legal Services for a very long time in a variety of capacities and has extensive expertise in dealing with the vulnerable populations that most legal aid programs are designed to serve. And in addition to giving us her opinion and experience with various kinds of technologies, all from conception through implementation and then evaluation, but also may be able to answer some questions regarding just sort of how the public responds to and deals with as we get ready to do recommendations. Those of you who might have specific questions there, I think she's also an ideal expert to respond to those. So that's
perfect.
There you go. Thank you.
Great. And if can you just direct me to where I can share my screen? We've got our PowerPoint up, but I'm sorry, we don't use WebEx, so I'm not entirely sure what to choose.
If you kind of scroll on the WebEx screen, there are these little icons that'll show up at the bottom of your screen. Do you see them? Like a telephone with a video camera?
I see it.
Okay,
Yep.
So there's one that says,
yes.
right, the second one from the left, it says, if you hover over it, it says share content.
Okay.
And you would select share my screen, and then you would just go to your PowerPoint.
Excellent.
Perfect. We can see it. Well, it's loading, but yeah.
Okay.
I think you got it working. Just give it a second.
Great. Well, thank you very much for asking us to talk to you today. And hopefully, this is Allison, and I'm the Executive Director of Montana Legal Services. And with me, I have Angie Wagenhals, who's our Pro Bono Coordinator. And Joyce is exactly right. We've been using technology to help clients for probably 20 years, helped immensely by the Legal Services Corporation's Technology Initiative Grant Program. We've been able to take advantage of funding to help build technology solutions to reach rural areas. Joyce went through some of our challenges, and for those of you who've been to Montana, it is a beautiful state, but as you know, it's very sparsely populated, and while we may like it that way, it also makes a huge challenge to get services to people in small rural areas. We started using technology back when people were saying, what's a website? We built a nice client website. We added live chat to it. We heavily invested in using automated forms. Our court system didn't even have forms, and so we designed them working with the court. And then we automated them. We've helped set up self-help centers. And technology has been a piece of everything we do, but it's not the be-all and end-all to everything we do. It is how we do things. We couldn't reach as many people as we do without using technology, and so it's kind of at this point baked into how we think about things. We served about 3,000 people last year directly. We only had 15 case handling attorneys for the whole state. But through our web presence, we reached about 60,000 people. And that's really why we try to use technology to deliver services. What we're going to talk about today, and then answer any questions you have, is one of our new initiatives, Ask Carla. Carla Gray was the second woman on the Montana Supreme Court. She was a champion for access to justice. She was very involved nationally in leadership for Supreme Court justices around access to justice issues, and sadly she passed away last year. When we were developing this, we were trying to figure out what to call it, and somebody said we should just call it Ask Carla. So we asked her husband if she thought, and that's a picture of Carla, she would appreciate it, and if anybody, lots of people know who she is, so especially in Montana, we decided she would love it. So that's why we named it Ask Carla. It also is a much more personal touch than some other things we could have called it. And we think that personal touch helps people, both attorneys and our client base, come to it.
I just want to interject for a second. We're having trouble with the PowerPoint loading, so I'm going to show it independently on this side. I got it from my email. So
Okay.
when you switch slides, just let me know, and I'll go ahead and advance the PowerPoint presentation.
Okay. So we're switching from the first slide to the second, and Angie, who's our pro bono coordinator, is going to talk to you about the need and the process for development.
Yes. So are you guys okay? On the second slide, you should see 3 points.
Yep, we got it.
Okay. All right. Then we'll just assume we're good going forward. So I think that there are 3 main things to consider when you're looking at developing a new technology project, and in particular one that provides direct services to clients. We had worked for a long, long time to try and develop and look at different options to develop this kind of site because of the needs of our clients. In Montana, we know that about 50% of clients go unserved or underserved due to lack of resources. So we know there is a great need for additional legal help out there, and we have the compounding problem of great distances to spread those slim resources that we do have. So when we started looking at this, we kind of pulled together our collective knowledge about our clients' legal needs, both through looking through our case management system for hard data and through our own attorneys' experiences of serving clients across the state. We also, we kind of look at this as another way to get clients in the door for Montana Legal Services. That is a big need here in Montana, just to make sure people can get to us and get to us pretty easily. So this site for us also acts like a feeder. Things can be answered quickly online, some things can't, and this kind of can help us divvy those up. So we knew the client need was out there. We also knew that pro bono attorneys in Montana were looking for limited scope opportunities. And we knew that from just, feedback from the private bar, but also from some formal surveying we did, asking attorneys what type of pro bono they wanted to do, what little bite-sized pieces they would like, and what they were looking for in an opportunity. And we heard from a lot that limited scope was something they were looking for, and that it was important to them that they be able to do it on their own schedule. So it's important to have that buy-in when you're looking at developing anything like this. In Montana, these online advice platforms they have some champions and some detractors, and so we started early on in the process to bring pro bono attorneys to the table and ask them what they wanted and how they wanted us to develop that, to avoid developing a site that no one would use and everybody would have issues with. So the last thing to make sure to look at is the specific challenges in your service area. For us, that's always going to be distance, but we also have some connectivity issues in certain frontier communities. So we needed to do kind of an audit of all of that and know what particular problems we may run into in attempting to launch a statewide site that would truly serve the entire state. Okay, next slide. All right, so we wanted to walk you through the process, and this is about as simple as we could make it, so please ask questions if anything is a little unclear. But when we started to develop this site, the first thing we needed was money to do it. And as Allison mentioned, we are a longtime recipient of LSC Technology Initiative grants, but this particular one came out of a Pro Bono Innovation Fund grant from the Legal Services Corporation. And it allowed us, among other things, to build this site as part of a broader limited scope menu of options for volunteer attorneys. One of the things I would stress is that ABA Free Legal Answers is certainly the place to start looking. It's a site that I'm sure you're all aware is developed to serve all 50 states and to function in much the same way. Clients post a question, attorneys post an answer. And unfortunately in Montana, we weren't able to work within that framework. We're the only legal aid provider here, and we have to follow Legal Services Corporation restrictions and requirements. And we couldn't get, after many years, couldn't quite get the ABA and LSC requirements and the development of that site to mesh. But it's certainly the place to start in that it's developed, it runs well, and it has the same functionality. So then you certainly want to take into account the barriers to development. For us, those were LSC regulations, attorney rules on conflicts, and a few local rules about how we interact with clients and use technology. You should look at these before you start developing the site so you know what changes you'll need in order to complete it. We had some that we kind of worked on as we were building this, and it makes it trickier and it extends the timeline by quite a bit. So you want to look at anything out there that may regulate, your screening, the provision of advice online, all of that kind of stuff, and we'll talk in more detail about that as well. We did have some of those barriers, so we then advocated for the change of some of those rules. Two big ones were the LSC rules on online intake, and in particular, the requirement that we contact the client after an online intake was done and speak with them in order to complete an application. And then the second rule was the e-signature rule that LSC had, or rather the requirement that a client sign a citizenship attestation or verbally confirm that they're a citizen. We had to ask LSC to change some of those rules to allow us to do a completely online intake and provision of services. Once you've got all the rules you need in order to actually run the site, you want to carefully select a vendor to develop the site for you. We needed the site built from the ground up because of the LSC restrictions we had to take into account we couldn't just modify the ABA Free Legal Answers site because they had hard stops on what they would take for income and asset requirements that did not jive with what LSC requires. So we selected Legal Server. It's our case management system, and they had some of the capabilities as part of the online intake system that they run to develop a site that would do this kind of thing for us. Last, you want to plan for a lengthy testing period. It took us a really long time to work out all the kinks, and I'll tell you, we're still working out all the kinks. But clients, attorneys, and administrators all interact differently with the site, and you want to make sure that it meets all the needs of those groups. Let me just make sure I got everything there. One of the big issues we ran into, and I would say this was a huge barrier for development, was the conflict rules and how they would apply, and I think Allison's going to cover that a little bit later on. So next slide, please, which is anticlimactic, but it will break many, many times. We are still dealing with small issues from time to time with our developer, Legal Server. Clients will interact with it in ways you never imagined. They'll post questions that are pages and pages long that will break it. And you know, when in testing, we never did that. We didn't write 16 paragraphs as a legal question. That's just not how we think. But there are certainly ways that clients and attorneys interact with it that bring up issues that you won't think through. So just know it's not going to work perfectly all the time, and be prepared to explain that to your volunteers and to your clients and have a backup plan for when it does break. All right, I'm going to turn it over to Allison to talk about the regulation and ethical considerations, which is the next slide.
Okay, so when we first started, Angie, talked about this a little bit, but this kind of a site is best run by somebody who is not a law firm, which is why the ABA Free Legal Answers, it's not run by somebody who would have conflicts, who would have, especially a LSC-funded law firm. But in Montana, we had no other outside entity that would take it on, and we really believed that it would give us one more avenue to meet client needs and volunteer needs. And so we felt pretty strongly that we wanted to have this happen. And as she said, we ran into issues with LSC rules around online intake. They didn't actually allow for it. And some of their citizenship signature requirements, which up until then had been required in writing, in physical writing. And we got them to issue a couple of program letters that cleared that up. We also looked at an issue such as, will attorneys be anonymous or will they be identified? And our attorney pool wanted to be anonymous. So that means they are hiding behind, not hiding, but they're standing behind Montana Legal Services as the law firm that's giving the services. And so the person asking the question, so we vet that. We actually review the advice and make sure that there's nothing funky going on because it's underneath, our malpractice insurance and our ability. But they're actually counted as cases, volunteer-handled cases for purposes of our grant funding. And we made that choice deliberately. One of the ways we could have gone with this was we could have said, we're just going to have the volunteers give legal information, and then we wouldn't have run into all these problems. But we didn't think that would really help the client, and we also thought it would be very difficult to monitor attorneys only giving legal information, not legal advice. That's not what they want to do either. But then that dumped us into issues like, the LSC rules and then the conflict rules. So we have this site walled off from everything else that we do. Angie is the administrator. She is a non-attorney. We use our Rule 5 that talks about pro bono clinics and actual knowledge. And so if Angie has an actual knowledge of a conflict, then we will not be able to handle that. But if she doesn't recognize the name, we're not running conflict checks on this service. Our state bar has given us informally we've not sought a formal opinion on that, but our state bar has agreed with us that is probably the best way to do this, to get the services out within the resources that we have. One of the other things you have to think about is what level of income and asset screening do you really want for purposes of a site like this? And this is where we had to depart from ABA Free Legal Answers. They do a pretty light screening, and that's really something they wanted to do, right? Our volunteers in a small rural state like this probably would not have been happy with us if we did a very light screening, because they would have seen that as taking paying business. So we do our standard screening, and unfortunately, it has to be in order to get through all of the LSC regulations in an online environment, you kick a lot of people out a little earlier than you would if you were screening them over the phone. But what it does is it tells them to call us. They are put in an online application, which then somebody talks to you about. And then we can either get them a phone advice appointment at that point, or we can give them a way to get back into Ask Carla if what they really want to do is type their question and get some answers. I'm going to stop there and see what questions you guys have.
Hi, I'm Kevin Moore.
And hopefully you're still there, because we can't hear you.
Can you hear me now? How about now? Can you hear?
Yep, now we can hear you.
Okay,
yes,
great.
We can hear you now.
Okay, I'm Kevin Moore, a member of the task force, and I'm a little bit interested in your use of, I guess it's Montana Rule 6.5, correct? I mean,
yes.
In terms of limited legal services. Do you have any instances where the volunteer lawyers can be retained by the people who call in, or do you just make it available, just the answers that are made online, and that there is no option? Because in the rules, in the ABA model rule and the California rule, there is that option that if the lawyer is retained by the person who comes in for limited legal services, that lawyer then has to run conflicts checks and the like.
Yeah, the way we have developed the site, that's not an option. It just would be too complicated to allow attorneys to take cases directly from the site. So they're just providing one legal answer per legal question. And I should say, don't quote me on Rule 6.5. As Allison said, I'm not an attorney, but that's the number that sprang to mind, so I'm relying on my memory of that. But yes, what we do look at is we monitor the questions and answers. If we see one or our volunteer identifies one that is too complicated to be dealt with on online advice or that needs follow-up, that's where we're going to pull that client in and look at more extended services, or an actual in-person or over-the-phone advice appointment. So we kind of deal with it a little bit differently. Did that answer your question, or did you have any follow-up questions? Sorry, we can see a little bit and hear some. I think we're okay on audio, but.
Hi, this is Randy, staff to the task force. I just had a question about is there any data mining that is there any data mining that's feeding Ask Carla in terms of the chat function? Is there data mining that helps Carla understand questions better? And is there data mining on the answers that are being provided? I think you mentioned that there was a quality control that was being used to review the answers being given. Is that also feeding Ask Carla? Or is it not really that type of system? Am I overthinking it?
It is not that type of system right now, but we did receive follow-up funding to develop that type of system. So we are right now in the process of beginning a project where we will both help on the front end and have some mining of the question and feeding of information to the person before they get the attorney answer.
Mm-hmm.
And then on the back end, we're going to mine some of the answers that have been given and suggest answers to volunteer attorneys based on successful questions that have been answered in the past. So you're on the same track we are. Doing this is a particularly complicated undertaking, and so we really are staging it out. You know, we just want it to, let's just ask and answer questions first, and then get to the next piece.
Great. Do you have an idea of how long that next sort of stage 2 might happen?
Probably 2 years.
2 years. Okay, thanks.
Alan.
Yeah, hi, this is Alan. Curious to know as to what the utilization is. Like how many questions are fielded on a regular basis? Do you have any data on the types of questions? Are there any FAQs?
Yeah, the nice thing is that because it's run through, on a separate but similar platform of Legal Server, we get all the data that our case management system is capable of pulling. So I believe we're up to about 130 questions answered. I will tell you that we have had to take it offline a few times or stop promoting it because there were some major issues with the functionality. So we've had some quiet weeks. But we're averaging, I would say there are probably about 5 questions answered every week, which in Montana is not bad. It spikes every time we do outreach. So when we have little trifold business cards that we take out, we usually see a spike there. So it's used. It is not, other states use it heavily. We just have not done a ton of outreach recently to promote it. Because we're trying to fix it. Mm-hmm.
Yeah, and because our population is so much lower, we do like to develop things here because you have a little bit more breathing room.
Yes.
If something does break, we find that to be helpful to us.
Yes.
And then in terms of data, the types of questions?
Yeah, we track the types of questions, and we get basic demographic information, so we can pull all of that and give you some. We can get a general picture of the most popular types of questions and the types of clients that are asking them and where they live, all of that kind of stuff. So that data all lives within the site, and we can pull it through reporting.
And it's mostly family law, is that right?
It's mostly landlord-tenant.
Mostly landlord-tenant right now.
That's great. Thank you.
Lori?
Do you have, what is your average response time from the time someone posts a question to the time that they get a response back from a lawyer?
Yeah, we've been telling people it's 3 days, and that is what we get from our data is the average. I think most questions, we send out a weekly reminder email, so most questions at the most are getting answered within that week. But what we see is most of them actually get answered within a day or two of when they're posted. But those funky ones that no one wants to touch sit there for a little bit longer and kind of skew that average a little bit. But it's generally around 3 days.
Is there a question from somebody else over here? Donna?
Yeah, this is Donna Hershkowitz. I'm with the State Bar. I may have missed the discussion of who your volunteer attorneys are and how the questions get allocated to them.
So we don't assign, well, I'll answer the second part of your question first. We don't assign volunteers to questions. They come in and they can look at the queue, and the queue organizes everything by type of question and by county of dispute, because that's one way our attorneys avoid conflicts of interest. They answer questions outside of the county they practice in. And then the attorneys can select the questions from there. They can preview it before they take it on and see what the actual, and they do a brief conflict check before they see the text of the question. So attorneys are self-selecting the questions they want. And then we have volunteers that run the whole gamut. We have bar staff that volunteers as their pro bono because it's particularly friendly for folks in those types of positions. And then we have, seasoned family law practitioners that are retired, and this is what they do. And we have some brand new attorneys that this is how they're starting with pro bono. So it runs the whole gamut. We did a CLE to recruit when it first launched, and that's kind of where our biggest influx of volunteers have come from.
Yeah, and we haven't had to do another one, but we probably will in the next 6 months or so.
Yeah.
And so one of the things Angie mentioned is we do want county of dispute in there so people have the option to pick things outside of their county, and that often the pro bono volunteers will check for the conflict anyway, even if they don't have to. And we don't, if that's what they want to do, that's absolutely, they do that, right? We leave that up to the individual volunteer.
Quick follow-up. Does Montana have a mandatory pro bono requirement?
No.
No. We have a strongly encouraged pro bono requirement, which was actually adopted by Carla Gray.
Yes, Leah.
Hi, can you hear me?
Yep.
Okay. My question is your income screening. What is the cap on the income? Is it 125% of federal poverty?
Yes.
Okay. Has anyone that's been involved in this effort thought about how this kind of tool might be used for those above 125% of income, perhaps on a pay basis? Has that come up at all? Are there folks interested in doing that?
So that is not in our state because, again, we have the issue of only one legal aid provider. ABA Free Legal Answers, I'm getting to part of your question first, is higher than that. Mm-hmm. In fact, it's a very loosey-goosey questions. You should look at their site. If you want to go higher, that's the version. Things like LegalZoom and Rocket Lawyer do some paid versions of this. We have not looked at that.
Okay. Thank you.
Sure.
Other questions? Yes, Johan.
I couldn't tell if it was just a matter of the way you said it, but you said that your volunteers all have to come into your office in order to be able to pick up the questions and answer and that type of thing. They're physically in your office?
No.
Oh, okay.
We must have missed out.
Yeah.
No problem.
We don't have enough offices for them to come into. So they just log on.
I lived in Montana, and I was like, I couldn't imagine how that would be possible. So.
No, we assume they're in their pajamas on their couch.
Other questions? Randy.
Is the current program open source? And in the 2 years that you're going to turn it into something that is a little bit more sort of artificial intelligence-y, is that all going to be open source so that any, perhaps, say, an entrepreneur who wants to deploy this in a for-profit sector could use it and improve it?
So it is not open source. We were unable to find that type of a vendor that would do for the money that we had. It is all done by legal server PSTI, and you have to talk to, I think they are willing to, license it to others, but I'm not sure what that would look like.
Thanks.
Other questions? So Allison and Angie, did you have other issues that you wanted to cover?
No, I think we tried to hit the questions you had asked us to talk about. So.
And our contact information is on the last slide, and you can. I would say email is probably the easiest way to get a hold of both of us. But please feel free to reach out if there's anything we can provide follow-up on, and be happy to give you screenshots or anything that we use to develop it.
We can give you a demo of the back end, too.
Yeah.
Terrific. One more question here. Randy.
Randy again, State Bar staff. Have there been any complaints by users? And if there are complaints, is there a complaint process other than the attorney disciplinary process that you guys employ for accountability for this program?
So we have not had complaints by client users. We've had plenty of complaints from attorney users who lose their passwords and all that kind of stuff. But for the client users, we have several disclaimer screens and information in the site that tells them how to file a grievance. That's a requirement of the Legal Services Corporation. So that is how we handle that. There are not any that I'm aware of, and Allison may know more details on what we would do.
Yeah, because they're clients of ours, they would go through our normal grievance process if that's what they have. If we have issues with volunteers, then we handle that just as we would handle any volunteer.
Yeah.
That we need to talk to about whatever they're doing.
We have a generic email address on the site that just forwards to me. I deal with those. They're all, and then we're lucky in some ways in Montana in that all of the attorneys know who I am. They just call.
Just one quick follow-up. Are the participant attorneys required to maintain professional liability insurance or contribute to a security fund of sort?
No, we provide their malpractice insurance through our malpractice provider.
Great.
Joyce?
Can you do a sort of a summary of all the different venues by which someone can get services in Montana? I think just thinking about the fact that you're the only legal aid organization for the entire state, thinking about your population, thinking about the remote needs, and also I'm just personally interested, given your experience with live chat and video conferencing. I mean, can you just kind of give us a rundown of what, your average person who meets your low income demographic, how many choices do they have? How many ways do they have to connect with you typically? And I realize that's kind of a hard question, but I think just understanding the whole ecosystem that this might exist within, because I know this is not your only technology solution, might be very informative.
Sure, I'll start, and then I apologize, but I do have a hard stop here in a few minutes, and I'll let Angie pick up the rest of the questions. We believe in keeping a door wide open and reaching as many people in rural communities as possible. So we do everything from, we have the traditional telephone line where people can call us. We have an online intake application where people can fill that out and then get a call from us. You can schedule an intake appointment. We have intake appointments they can book right into a Gmail calendar and set the time they want to talk to an intake worker. If they just want this online service, this Ask Carla does a full screening, but because the technology, we were unable to develop all of the exceptions to the LSC rules. That's why it's kind of locked down in terms of only 125% or lower. And then we actually do a lot of travel. Yeah. We have, we believe technology is part of it, but underneath it all, you have to have those personal relationships in small town communities. We have a robust medical legal partnership with 6 rural health centers that screen every patient that comes in for civil legal needs. And then that would get routed into the system by fax, actually, because health centers like to use a fax machine. We also then, we have an outreach person who does a significant amount of outreach around all of these things, regularly sending out information to social service providers, communities. We actually have 4 of our staff this week on a little road trip through eastern Montana, which if you've ever done it, they're quite the troopers.
If it tells you anything, it coincides with the bucking horse sale, which is the sell-off of wild horses so they'll be there for the peak of that.
We do use live chat on our website. You cannot apply using live chat. We made that decision a while ago, but because the online application is so easy and we have the ability to just immediately call somebody back, or hopefully as quickly as possible, we didn't really need to do that by chat. Does that get to what you were looking for, Joyce?
Yeah, so I guess you guys aren't doing any kind of video conferencing anymore?
So not very much. No. We've played with it numerous times over the years. And what we have found is our client base prefers to just talk to you on the phone. If it's a choice between in person, which they like, then the video conferencing added a level of complexity that did not benefit the client. So we tried putting terminals at social service providers. We tried, we had terminals in courthouses. We are hooked into the court video conferencing system, and occasionally we use that for appearances or for witnesses. But no, we are not. We have moved away some from video conferencing. We may try it again, but we've moved into the more web-based. We do a lot of texting with clients too, to remind them of appointments and to get things signed. We've moved into that as opposed to video conferencing.
Thank you.
Hi, this is Heather Morris. Two questions. I know you mentioned that you were seeing a lot of landlord-tenant. Are you tracking through your analytics what types of cases are coming through? And then as a follow-up, and this is more the analytics, are you seeing it more coming from a desktop when people are applying online versus some sort of a device, whether it's a phone or a tablet?
I think the first part of your question, the desktop and tablet information, I don't know that we capture that. I don't know if we've looked at that. My suspicion is that we do, because we do in Legal Server, but we have not looked at how questions are coming in and what technology they're using. In Montana, most people are using their smartphones to interact with the internet and to contact us, so I assume that's where that's coming from. And I'm sorry, can you repeat your question about landlord-tenant?
No, I know you had mentioned that. I know you had mentioned that a lot of the cases that you were seeing were landlord-tenant, but what are some of the others? I don't know if you were tracking the demographics of the types of cases that are coming in.
Yes, we are. So for any of you that are, I don't know if any of you are legal services connected, but there's a very specific list of legal problem codes, and that's how Ask Carla tracks that. So, we know security deposit versus repairs, those kinds of questions. So we have that type of breakdown across legal issues. So we do track all of that. Landlord-tenant, and a range of different landlord-tenant questions is our number one, and then our second most popular is family law. And a bunch of different things fall under that.
Lori.
I think you said, you guys, this is Lori, that there was about 5 questions a week coming through. What is the ultimate goal, and what percentage of impact would that make on those who aren't receiving legal services who need it?
So I don't know that we've put a number on what we'd like our goal to be. Our pro bono program really functions to try and catch everybody that comes in and provide at least advice, so that our attorneys can do the impact litigation and the more complicated legal issues. So I think we would be happy if we heard from our client community that they felt like that they had an opportunity to get advice whenever they had a legal question. I don't know that I can come up with a number for you, but I assume that if we looked at the number of people that would qualify for services with us versus the number of people that do contact us, the medium would be somewhere in the middle of where we'd be happy. But I think for us, any resources available that actually provides advice is a win. I certainly think we could get those numbers up there, but I don't have a good guess of what that would be.
Abhijit?
This is Abhijit. Which problem codes do you use? Do you use the LSC and SMI problem codes?
Yes.
Okay.
Would you? Yep. You're welcome.
All right, Allison and Angie, I know we really appreciate your taking the time to be with us today, and I know you're on a tight schedule, so we even appreciate it more, and we thank you for the time you took.
Our pleasure. Thank you, and please don't hesitate to reach out if you have any other questions or follow-ups. Happy to help out.
Thank you so much.
Thanks. Take care. Bye.
Bye. Okay, so now we're going to break into our subcommittees. I think we decided that rules stays here, and the other 2 are in the 2 next door rooms.
Present. So moved.
Second.
Lori seconded. Are we good? All in favor?
Aye.
All opposed?
Definitely.
Any abstentions? Okay. So I think just to reiterate what was said earlier, that I think is really important for us is that as we've gone through these discussions, something that we've sort of felt in limbo about, I know I have, has been, well, what are all the other sections doing? So now that's been clarified this morning that it doesn't matter what the other sections are doing, that we can propose things that are conflicting and completely independent. So something that I'd like to propose is, it sounds like a lot of the other sections are creating new stuff. And I know. Oh, is there any public comment? Okay. Anything else? Okay. So I'd like to propose that we, in our approach to the proposal, we take the opposite approach, which is kind of the push that Lori, Alan have been making since the beginning is, how do we minimize it? So when we're putting this out for public comment in a month or two, what we're going to be asking for, so when we do our next vote, we're not going to be asking, well, are you on board with this idea? What we're going to be asking is, are you on board with presenting this idea to the public for their comments? And I think that's a really important distinction because we know that we don't all agree with things, and we also have been wanting the public's feedback on these items. So I think this is a really great opportunity to obviously contribute our personal views so that we can still get both sides of the picture, but also to focus on what we want feedback from, and to take some of these more ambitious ideas that you've put out there throughout the last few months and get them out there to the public and see what kind of feedback we get. So with that, I'm really excited to get started with section 5.4, which is the fee sharing. So if in the materials, if you have the 77-page ones, it's page 37 has the rule listed there. So, yeah. Okay, do we need to take roll again or just?
The next time we vote on anything, we need to do a roll call. We can't substitute the initial roll.
Okay.
Okay, for the record, I'm present.
Thank you. So does anyone want to get started with their thoughts about Rule 5.4, which is the fee sharing? Take it away, Lori.
So I looked at the rule itself and actually submitted a suggestion for, can you hear me? Hello? Can you hear me now?
No.
Nope, this one's not working. All right, can we hear me now? Yes, okay. So one of the things that I was hoping our subcommittee could bring out of this task force is a recommendation for some sort of stark change, keeping in mind that the purpose of, I know a primary purpose that we've been tasked with is protecting the public. So I just really spent a bunch of time thinking through that after the last meeting. And I really wanted to suggest, first and foremost, that we just rewrite the rules to take out all of the no's for fee sharing. In terms of fee sharing itself, that keeps attorneys in the mix 100%. So fee sharing with lawyers means lawyers are still in the process of delivering legal services. I understand with UPL, that's a statutory issue as well as an ethical issue, and I just really wanted to focus on something that maybe could provide some real impact. And so I've added a comment and made a suggestion and rewrote the rule, taking out all of the cannots and no's and nots, to say lawyers can fee share with no other restrictions other than client has informed consent of those fee sharing arrangements, and that the attorney must maintain their professional independence. And after the last meeting, I really thought through the things I had heard. A couple of notes that I made of potential issues. One is that lawyers would not be able to maintain their professional independence. This is a thing that I've heard quite a bit. And I just don't find that I believe that's really what most people think when it comes to lawyers, including, I'm hopeful, lawyers themselves. If we are the stewards of justice in the legal field, if we're in charge of making sure things happen, then we should surely, as an industry, feel comfortable maintaining professional independence when we partner with others. The other thing was this idea of continuing protections. And I'd really be interested in hearing from those who are more experienced what protections we're trying to continue. It's no secret that I believe any industry that doesn't meet 80% of the need isn't really protecting its consumers. I think zero protection for that majority isn't a protection. And so, but I'm also here to learn. So I think I'm really interested from the other members who are more experienced, what protections, specific protections, we want to maintain as we make these suggestions.
Thank you, Lori. Anybody have a response? Professor Moore?
Okay. I think one of the main protections we have to have is if you take out all restrictions on fee sharing, what you're going to have are shops set up strictly to refer matters to lawyers. And then those people who are referring matters to lawyers will not necessarily refer them to the best lawyers or good lawyers, but those lawyers who are willing to pay the most for the referral. That's one of the primary concerns about putting a limit on fee sharing with non-lawyers. We're not talking about multidisciplinary practices. This is something that is a very real concern that existed to a certain extent and still exists to a certain extent under, hidden from regulation, where you have runners and cappers who are referring matters and are being paid. So unless you have these provisions on the books, and there is a statute that prohibits runners and cappers, so to eliminate all fee sharing, what you would end up having to do is also make statutory changes here in California. As far as independence of professional judgment, it's going to be a substantially different situation where you have a lawyer running his or her own shop or running a shop with other lawyers, in other words, a firm, and where you have a corporation or some other type of entity that is, in essence, trying to drive a profit and is going to be, to a certain extent, calling the shots and may place limits on a person's ability to use resources to advance monies for the client's case, to limit the extent to which a lawyer can represent the client, and just saying that the lawyer shall maintain independence of professional judgment isn't going to make it so. These protections are here to ensure that the lawyer does not have those outside pressures coming to bear on his or her ability to represent the client competently and diligently.
Ellen?
I have a question for you, Professor Moore. Man, I was working right before we. Do you think it's possible to maintain the restrictions on runners and cappers, like leave those rules as is and still modify the fee splitting rule?
I think it might be possible. I'm not sure that it will be possible because who's to say what is a runner and capper when there is no restriction on the lawyer's ability to share legal fees with a non-lawyer?
And I believe the statutes we're looking at are looking at the Civil Code, Business and Professions Code 6151 under for unlawful solicitation, which defines runner and capper, and the statutes that follow as to what it's unlawful for them to do. Andrew?
Might we be able to still accomplish the goals of protection in 5.4, but also relaxing fee sharing if we were to regulate the fee sharing entities?
I'm not sure what you mean by fee sharing entities.
Well, as you described 5.4, if there's an organization or establishment that is essentially being paid referral fees to refer clients to lawyers, if whatever entity or person or organization that was subject to some sort of regulation, then maybe the goals of protection could still be accomplished.
Okay, there is the point. I mean, are we talking about legal referral services? In extent, we already have a system of regulation for legal referral services, and in California, unlike many other jurisdictions, for-profit legal referral services are permitted. Lawyer referral services are permitted. So we already have, to a certain extent, a system of regulation in place. The question is that can we upend a series of regulations of prohibition on sharing fees? And what we're talking about really is a sharing of a percentage of whatever money is coming in, and what pressures might be brought to bear on a lawyer under those circumstances, particularly if costs were to be advanced to the lawyer to handle it. I mean, in other words, we're already seeing this to a certain extent with the litigation funding entities that are out there that remain, as far as I understand, largely unregulated in terms of advancing monies for cases and then taking a certain amount out of the case. It's an area that we should probably explore to a certain extent to get a better handle on, to see where we can go with allowing it. I'd be really hesitant to remove this rule. I know, Lori, you want to say out with regulation, but I just think that that's kind of a non-starter unless we can show with reasonable certainty that this is going to increase access to justice. And I'm not sure that we're necessarily going in the right way. I think the appropriate way to go is in steps. And this is one step that we can bring in non-lawyers to participate. Let's see how that goes. In other words, this is almost like a pilot project. We'll see how this is going with lawyers retaining some control. The step after this step with the Rule 5.4 as drafted, this proposal, as originally drafted for the most part by the ABA Ethics 2020 Commission back in 2011, then go more toward a full-blown MDP provision where you actually have, you don't put the limits on ownership by non-lawyers, that you could have non-lawyers owning a majority share of a particular entity. And then even beyond that, you just simply have investment in entities that are providing legal services. But I think to just say, let's just go full bore into it, I think that's going to be a non-starter, not just for the legal profession. I think it might be a non-starter for the Supreme Court, which is pretty much charged with regulating lawyer conduct here in the state of California and throughout the country.
Only work. Oh, here we go. Maybe? Okay. So, you know, part of our charge was also am I here? I'm back.
Yeah, it's the wireless
Just get them all together and see what works. Okay. I don't think that we should be deterred from exploring these options just because they're unlikely to resolve. You know, we want to take both approaches, right? The what our first step is, but also what our end goal was. So I think we should still continue to look at what it, you know, now that we've acknowledged business and professions code, well, that's something else that the legislation would have to change. But I don't think we should say let's not do it at all, or that it's not a good idea. But that it should just be explored further to maybe try and prove up why it might be a good idea. The other thing is that having a rule doesn't deter bad conduct. The lawyer referral services, as far as I'm aware of, are not very good. People tell me all the time they call the lawyer referral services. Somehow I'm getting referrals from a lawyer referral service and I'm not signed up for anything. So I'm not sure where these people are going or where they're getting these referrals, but I don't necessarily think that the ones that exist work. And people still send, you know, other attorneys send referrals not to the best attorney for the job, but to the attorney that pays the most. So I don't know that, I think that the intent is good and I appreciate you for raising it, but on the other side of it is that doesn't actually stop bad referrals from happening, and that maybe the economy in this case would actually weed some of that out, because an attorney can only refer so much of their profit, right, before they stop actually profiting. So those are my thoughts. Lori? Oh, and then Leah?
So I wanted to address a couple of things. First, we have some real world experience in this room and on this committee with what's possible. So I thought I tend to be the person who's like, blow it up, let's stop doing all this. And I thought I'd take a minute to talk about some real changes that I've watched happen. I'll submit that I still haven't heard in any of these meetings how I hear what could happen, what might happen, and they're all very risk adverse, but I have yet to hear any data that backs up this is what happens when we've tried to relax these in the past. And so we're sure these bad things will happen if we relax these rules. So we've got people want data on both sides, and there's just not really, we're talking about some uncharted territory. But I wanted to remind us that I believe we're here to talk about access to justice, innovation, and technology. And in order to increase access to justice in an innovative way using technology, the more we constrain things, the more regulated we are in the beginning, the less likely we're going to build a system that actually makes any impact. That is going to fail. It is doomed to fail if it's so regulated that we really can't explore all the possibilities. Because innovation isn't about the smallest step. It's about big booms. That's what innovation is. And so I wanted to kind of go back to that idea because that's what I think had so many of us excited to be here in the first place. And talk about a group, a volunteer group in Nashville, Tennessee that is making impacts all over the place. There's a group, I've talked about this briefly, a volunteer national group called Code for America that is volunteer technologists and developers, all kinds of things to build products, all kinds of people to build products. And we have a local branch in Nashville. And we invited that group to be a part of several things, a couple of hackathons. We invited them in to build products with our legal community, and they have done amazing things. Number one, they've built a power of attorney for immigrant parents who might be detained or deported. It's a limited power of attorney. It was built into our statute in Tennessee and is now accessible online. There is no data that is kept. This entirely free website, anyone can go on today and download a limited power of attorney so that their children are not left without caregivers if they are detained or deported. This was a huge issue in Tennessee. We were raided back in February. A small town was raided, 97 people were picked up, 500 kids didn't go to school the next day in a little tiny town. So an invitation to this volunteer group brought that along. This group had more volunteers on that one project for legal than any other project they had in their entire history, including a 4-year-long project. So in 1 year, they amassed more volunteers, more people who cared about helping those people than any other project they were working on. And I'm sharing this because what we're talking about is a group of dedicated technologists, developers, everybody we would need to help us build innovative new products who just needed an invitation. And the more we regulate, the less likely we are to extend invitations to anyone to help us with these problems. The idea that lawyers are going to be influenced by corporations, you're talking business. If lawyers aren't influenced now in making profits, they're probably not running profitable firms. There's always some influence in business in terms of profits, but that works in every other professional industry. Doctors and hospitals, I guess I'm just really frustrated that we keep coming back to this same idea that lawyers are the only ones who can provide legal services on one hand, but on the other, they can't be trusted to be influenced by outside forces. That doesn't ring true to me, not the lawyers that I know. We also have our first video remote clinic popping up in Tennessee, and it is the Tennessee Access to Justice Commission that put that together with Vanderbilt law students, and it had its first client about 2 months ago. And this is a big deal for us. It's very similar to what we are seeing in other places. But it is a for-profit video conferencing company called Legaler who is donating their much better system to all of these instances. And again, I'm sharing this because these are people who are building products, who are doing things not related to legal, who, because they were invited into the space, are changing how we're going to provide legal services in Tennessee. And the more that we insist on attorneys only, I appreciate the rule from 2011, but it's 2019. You guys have had 8 years to put this rule in place. I think we need something much more, a suggestion. Let's hear from lawyers. Are they really worried about being influenced by money from corporations? Is that really an issue? Because again, I think we've made that assumption.
Leah?
I think, just going back to your question, Andrew, I think what you were asking about was entity regulation. And so to get to the concerns that are being raised, these rules are really designed. If we were able to move to or to add an entity regulation component, would that be a way to address some of the concerns that I think are suggested by all of these restrictions on fee splitting? So would there be a way to go in and essentially, as part of that regulatory framework, do some kind of assessment or audit of the extent to which money is influencing legal outcomes? Because then you could open it up on the front end, but use your regulatory structure to kind of address the risks that you anticipate. So I thought maybe you were asking about that. And I don't know, Professor, if you think that that might be a way to try to address the potential harm that would be caused. It's a different modality than simply trying to regulate the individual lawyer or the practitioner or the law firm.
Well, the, the entity regulation, can everybody hear me? This is on. Okay, the entity regulation is, we have it in New York and New Jersey. It's called law firm regulation. And the way those two jurisdictions have done it is they've taken a couple or three rules, which just prohibit, it's just, you add the phrase or law firm. So you say lawyer or law firm. Here in California, the focus, of course, is on the lawyer, the individual lawyers. I'm not sure what could be, how much entity regulation. I think it's something it's worth throwing it out there. I know Mark Tuft wrote a memo that we had for the last meeting, at the April meeting, on the concept of entity regulation. That would be a possibility, but I'm not sure that the entity regulation in and of itself does anything more in terms of this fee sharing and independence of professional judgment. How much more it would do, other than, you could go after the management committee of a law firm, the members of the management committee or the managing partner of a law firm. In fact, about 10 or 15 years ago, Delaware de facto engaged in entity regulation by ordering that two law firms be dissolved because they failed to comply. They failed, the law firm as a whole, with its members. It just ordered each individual member, partner of the law firm, to end their association. And that was held up by the courts in Delaware. So we can explore it. I'm not sure whether that is the answer. I guess well, it's no surprise I'm a little bit conservative on these things. And it's not like I'm out to protect the profession. It's just that I would hate to see us go so far. I think it's fine if someone wants to make that proposal, that we can include it in our report. Both entity regulation, law firm regulation, or also include a concept of eliminate all prohibitions on any fee sharing in Rule 5.4. But I think we should also have alternatives that are presented to the public. So I guess it's the menu of options that Randy was referring to before.
Thank you. So I'd like to, Rule 5.4 there's a lot, it's loaded. And it does start with a lawyer or law firm. So I'd like to break it up into different pieces, and I'd like to kind of see if we can come up with a proposal that maybe isn't as completely open as Lori suggested, although her proposal was not 100% open. But see if we can break it up and then consider, as part of that menu, we might want to have a question or some feedback from our public on, do you want this open? Should we eliminate all barriers to entry and fee sharing? But let's see if we can put a little more thought into each piece of this. So, yeah.
So we don't have, so to my knowledge, we don't have data on what would the world be like in the absence of the longstanding prohibition on fee splitting and the subset of compensation for referrals. But we do have experience with discipline cases where those standards are honored in their breach. And so the review department at the State Bar Court has confronted these things many times. I can think of 2 cases that the ethics hotline uses frequently, in the matter of Bragg, in the matter of Nelson. And these are situations where you have a non-lawyer office manager who comes into a law office setting and acts as if there were no prohibitions on fee splitting or compensation referrals. Unbeknownst to the lawyer, this person takes over, starts signing up clients, starts settling cases in ways that are harmful to the clients. And so they act as if there were those rules in place and clients have been harmed. And the lawyers in those 2 cases, these are lawyers who discovered what was happening, had to come in and turn themselves into the bar and say, hey, I basically allowed a non-lawyer to partly take control of my law office, and now all of these things have happened, and I'm, turning myself to make good on it, and they do end up getting disciplined for having allowed UPL, aiding UPL, fee sharing, fee splitting, because the non-lawyers were interested in the profit they can make by signing up people, by settling cases and getting the instant contingency fee into their hands. They had taken control of the trust accounts. And so not all of the examples I'm giving are responsive to your concerns, Lori, because obviously not all non-lawyers are bad actors who are looking to enter into a law office setting and through subterfuge take it over and let profit be the only guide. In regards to the institutional concern, we have long heard from the lawyers who are participants in the tripart relationship in terms of insurance defense. There was a AB 2069 task force many years ago where we had the counsels for the carriers and the defense lawyers debating on to what extent the current law protects the interests of insureds, because the defense lawyers were so constrained by what the policy imposed in terms of their ability to be zealous advocates, the amount they could spend on discovery, on investigators and other forensic tools, anything they needed to conduct a good insurance defense was all controlled by the carrier. And they felt like unless the bar stepped in to do something to moderate the control that is being imposed, that lawyers were being put at risk. Now, at that time, there was another task force, and we were only able to deal with a small part of it. This is the State Farm versus federal conflicts issue that remains as a comment in the conflicts rule. But they have long said, I remember the advocate, Carl Keener, I think was his name, on behalf of the Insurance Defense Council, that they really feel like, even in that well-settled circumstance of lawyers who are being told how they can represent the client by someone who isn't the client, but who's part of the tripartite relationship, was a challenge for them, that they wanted to do as best as they can to represent their insurance defense clients, but because of the limitations of the insurance industry and the coverage council and everything else, that they felt like it was a day-to-day challenge for them. And so, again, we don't have anything experiential-wise or data-wise that says that you get rid of the fee split, the fee sharing, the professional independence rule, that bad things will automatically definitely happen. But we do have a bit of a glimpse of what happens when those types of rules are either breached outright or are being challenged by the lawyers who are living under them.
Can I ask if we think as a whole in this group that small firms and solo lawyers would face the same type of issue in terms of representing clients because of the inability to hire the people they need, have the help they need, have the technology that they need? The insurance defense, that's an interesting argument for me, and one I absolutely understand, but I would submit that we're doing that in small law, and solo lawyers do that every day, all day long. They don't have the means or the investment or the opportunity to hire and bring on what they need to advocate for their clients as fully as they would if they had more money. So I think that argument works both ways. Insurance companies have the money. They're doling it out as they see fit. Small and solo firms, who I would submit are probably representing statistically more these unmet legal needs. They're the best group to I think, get access to those unmet legal needs, are in that same boat. And maybe that's why I'm pushing so hard for this idea. I have a skill set that most lawyers I know don't have, and it is not, it is simply because my focus has been on supporting their needs for a long time. And I would submit that I don't want lawyers doing what I do. That's not their best use. So what I'm suggesting is we talk a lot about fee sharing in terms of referral sources because that's the only thing we've really explored, it feels like, in legal. And allowing people to create entities together without those regulations allows people who have disciplines and skill sets that aren't lawyer driven can fill those needs that lawyers just can't right now. So if we're talking about protecting the public, how does keeping all of that additional time and investment in those firms help protect the public? How do we keep ignoring that 80%?
Okay, so I'd like to redirect really quick with a thought, which is at the moment that non-attorney partner the State Bar has no control over that person because they're not an attorney. Is there a possibility where if Lori and I want to go into business together, I tell the State Bar, Lori is my non-attorney partner, she has good credit, she does not have a criminal history of fraudulent conduct, but now she is approved by the State Bar because of that. But but maybe these other roles, now her ethical or her duties are elevated. She's not just a standard person, she's not an attorney, but she has higher obligations under some of these other rules we've gone through. And if our law firm, our entity, violates them, that she can no longer fee share with attorneys in the future. What do you think about that idea, and is that even a possibility?
I'd like to comment. I'd like to comment. I'd like to comment. No? Hello? Jeez, yeah. Okay, I'd like to comment. So I think that's a great idea. I do think like a couple things. Randy, your examples, it sounds to me like the lawyers at the end of the day did the right thing, right? They came to the State Bar with these things. So I think we should trust lawyers to do the right thing. I think that we have no evidence or data to support, life without these rules, and we have data to support otherwise. I think it's all going to be bad data because we have these rules, right? So our job is to continue to find these bad players and these examples. I don't think we're just in any of that. I think to Tara's point, I think there's some room there. As I reread these rules on running and capping, I think like, sure, nobody, lawyer and otherwise, should go to somebody in distress, right? Like we shouldn't be flinging business cards out at auto accidents on the 405, right? I think we all agree that that's not something we want to do. I think there's some room for like, hey, I'd like to build this technology and I can't afford it. I need to partner with somebody. I get pitched this all the time, and I think that's okay. And I, as a non-attorney, am happy to meet certain requirements, to Tara's point, to try and make that happen. I'm all in on the legal industry and have been for 21 years. If I have to get my DUNS credit rating, kind of run through, or whatever those kind of requirements are, I'm certainly willing to explore them. So I do think that there's maybe some compromise we can make here.
Leah, you mentioned entity regulation. Do you have any other comments on that, or Professor Moore or Randy, on whether entity regulation solves this problem or helps to solve the problem?
This afternoon, right? Does this one work? Sorry, thank you. Right, the other subcommittee is going to bring their recommendations forward. A couple of us, this isn't, okay, thank you. Really? A couple of us had the opportunity to attend a meeting in Denver that was put on by ATILS, the Institute for American Legal Studies. And entity regulation was, in fact, sort of the topic of this gathering. And it was quite interesting. It's focused on risk-based regulation. So I think when you talk about the risks that we're trying to address with Rule 5.4, and then you think about entity regulation, the way that this would work is that you set up the regulatory framework so that it is designed to target the risk. So if the risk is that money is going to control decision-making, you would have a regulatory structure that would specifically go in and look at via proactive auditing. So it's not a complaint-based regulatory model the way that we have now. So there would be auditing of decisions that are made by these entities to determine the extent to which, if at all, poor decisions or outcomes are being realized by clients because of the influence of money. So that's the way that would work.
under that model. And again, I think we're going to hear more about any regulation and risk-based regulation later this afternoon.
Anyone else on that? And then I'd like to go back to 5.4B, which is a lawyer shall not form a partnership or other organization with a non-lawyer if any of the activities consist of the practice of law.
Okay, I just have a question for Alan. If California were to adopt a rule similar to 5.4, would that answer some of your questions about getting into a partnership with lawyers and working with them? Would this be satisfactory to you? I'm not saying it's ideal, but the rule as drafted, proposed, 5.4, would that remove a lot of the hurdles that you've perceived in the regulation of lawyers and the provision of legal services?
I certainly think it would be a move in the right direction.
This one, 5.4, the one we're talking about, Rule 5.4. I'm looking at the proposal, this thing, that provides that, it says you can't enter into a partnership, or you can enter into a partnership with a non-lawyer, but only under the following circumstances. And then there are, 7 separate provisions that are listed. This is the one that was based on what the Ethics 2020 Commission came out with, which in all fairness was probably done in response to the extremely negative reaction that the Multidisciplinary Practice Commission's proposal received back around 2000 in the American Bar Association.
Although in your issues it is broader in the sense that it's not limited to regulated questions.
Correct, correct.
Okay, so as a starting point, would it be fair to say that we are in favor of, I guess, eliminating Rule 5.4, which is that a lawyer is not able to form a partnership with a non-lawyer? Do we agree that we would like to see a proposal where that piece of it goes away?
I agree with that.
In other words, it's not so much eliminate, but revise 5.4B to permit rather than absolutely prohibit partnerships with non-lawyers.
Sure.
In other words, permitted under certain circumstances.
Sure. Yes.
Okay.
This one doesn't work either.
Do you want to keep some of these provisions like B3, even in the modified version?
Well, I'm looking at the actual version.
Oh, okay, sorry.
Which doesn't have provisions, but I can open up. I think that's kind of the confusion here. Is I'm like, which one are we talking about?
It's
so
6 pages. It's 6 pages long.
The proposal has the 1, 2, 3. The firm's sole purpose is providing legal services. Is that what we're?
Yeah, I was just suggesting that maybe even in an option where this was a more generous provision, that some of these sub provisions might make sense. Like I was pointing out 3 and 6, maybe.
Sure. I just want to start with the rule as it currently exists and start taking away rather than adding. So I think we've all kind of agreed that it does require maybe a narrowing, but I just want to take it one step at a time. So I think we all kind of say, yeah, we want to propose something where there's attorneys and non-attorneys can fee share as the top level. And it sounds like that fee sharing might be a partnership. I mean, that's kind of a default when 2 people go into business together. You're either a partnership or you create some other form of entity. So now let's break that down into another level. Can that person be anything, any type of professional, non-professional, some person off the street, or does that person require some form of approval by the state bar, as we suggested or earlier, or does that person have to be regulated by some other entity? Does anyone have any thoughts on that?
So as a way of maybe, what's the word I'm looking for here, to add a little bit more assurance, maybe that person is somebody who's met some level of standard, like, I don't know all the details, but attorneys now have to get their fingerprints done, right, pass a background check or something like that. So maybe at the very least, there's that. I think trying to imagine what those occupations may be or those skill sets may be might be a little short-sighted of us, because who knows what those jobs of the future may be that could add value to the legal industry. But we want to make sure that they don't have outstanding warrants or anything like that. I think that would be, at the very least, a nice compromise.
So maybe a fair way to sum that up would be kind of the same process that attorneys go through to be approved by the state bar that the non-attorney would also have, which would be the background check, the fingerprinting, and like an ethics exam. Is that fair?
That's interesting. I hadn't considered that, but yeah, maybe it's an hour of ethics, whatever the required CLE
We have to
is
take a professional code of conduct ethics exam. It's a 1 day. It's completely separate from the bar.
Yeah, maybe that sounds fine.
I'm just going to suggest that there are many people and many ways that we can innovate. And the more barriers we throw down, the less likely we are to really build a diverse group to partner with lawyers. I've been a paralegal for 18 years in the legal field, serving lawyers on my own for 6, doing pro bono and access to justice for probably 15 years. And I have zero interest in sitting in an all-day ethics because I'm not a lawyer. If I was going to be a lawyer, I would have went to law school, which I had every opportunity to do. So the skill sets that we're looking for are different than the lawyers who are already there. And the more that we insist on making them look the same, the less likely we are to build that really diverse group that we're trying to build to solve the problems. So if it's back to increasing innovation, the more we keep it the same, the less likely we are to innovate. So I think some standard, fingerprints, those kind of things, becoming a part of the bar is actually a really cool idea. But I also think we're looking for more than just California people to come into California and help you guys solve these legal problems. I'm assuming that you don't just want California individuals and entities. And the more that you build a very specific subset of California requirements, the less likely you are to attract more money, more talent, more global options. So that would be my thought process there.
Would you agree with the subpart 3 in the proposal, which is lower than having to take an exam, but rather it says non-lawyers state in writing that they have read and understand the rules of professional conduct, the State Bar Act, and other laws regulating lawyer conduct, and agree in writing to undertake to conform their conduct to the rules, State Bar Act, and other laws regulating lawyer conduct?
Absolutely.
Any other comments on that piece of it, or what the entries or barrier to entries might be or not be?
One other comment. In the case of, like, say, venture capital, right, or some kind of non-individual person, I suppose it would be helpful if there was like a designated person that could represent those things for the organization. Am I coming across, like, for example, the way I'm interpreting this discussion is like an individual person partnering with a law firm, meeting certain requirements, But in the case of an organization like a venture capital group that wanted to provide some investments, say, to a law firm to help develop some product.
Okay, to respond to that, this has nothing to do with investment. I don't think that's the intention of the way this rule is drafted. This is what might best be called a modified multidisciplinary practice rule, in that it's somewhat more limited than a full-blown multidisciplinary practice rule, which would not put limits on the percentage of ownership by a non-lawyer. It might limit it to a non-lawyer professional, but otherwise there would be no limits on, what percentage of the people in the entity, the law firm. And if you look at the definition of law firm, that's a defined term in the rules, and it doesn't just include partnerships. It also includes law corporations. It refers to corporate law departments and corporations. It also applies to law offices and government entities and so on and so forth. So it's a broadly defined term. But as far as investment, I don't think this would necessarily be the tool to do that, to welcome the investment. What we would want to do is look at the laws in the UK or Australia that do permit outside investment. But this would be people who come in. We're talking about, Lori's talking about, they have something to offer. It might be technology to facilitate the delivery of legal services, but they would be part of the entity, the law firm.
I'm not sure that I agree with that, but perhaps you can clarify. If I want another entity to come in and build a product for my firm so that I can serve more members, I'm not allowed to fee share with them. So they can't actually go in on that product and we can't go in 50-50 where I offer the legal brains and they offer the tech brains, and then we share the revenue based on how successful we are. So I think this law does prohibit that because we can't directly share fees. I have to pay them up front, which I can't afford to do, which is why we need to change this rule.
I'm talking about the proposal, and I think if you're looking for investment in a law firm, in other words, the law firm is publicly traded, then you're going to have to go about it, I think, in a different way from what is contemplated by the drafters of this rule.
Mm-hmm. Well, I don't think we're talking about a publicly traded firm either, just fee sharing with non-attorneys that may be innovation and maybe another entity, small entity or large entity. Maybe Microsoft wants to go in on it, and we just want to share the revenue that's derived from our product. I think we're still prohibited from doing that under this rule, but maybe that is two separate rules. Maybe on one hand we're talking about a rule that maybe that's a part A and a part B, which is individuals partnering, and maybe there's a rule B, which is an investor coming in who's not involved in the day-to-day operations. Does anyone else have thoughts on that, innovators?
I absolutely agree. I think it's top level. Rule 5.4A, Rule 5.4A is top level. It just says it may not happen except this. And then all of a sudden everybody's got to jump through hoops. Nobody's going to do it. And the cat's already out of the bag. So you've only got the three modalities essentially. And I think you need to pay attention to the modalities. And the first is the venture capital, which is strictly prohibited. The second is the entity. There's no necessary reason to believe that the entity that provides these services would care to jump through the hoops. And the statute on the runners and cappers is completely outdated compared to what we can do with technology these days. Most people don't even realize when their information is captured and passed and circulated and advertisements, it all works on algorithms. So I think it's straight up, it's the first thing in this rule just needs to get rid of the exceptions in terms of providing and say you may share legal fees. Thanks for playing. Done.
Anyone else?
Professor Moore, I just wanted to make sure I was understanding what you're saying. I think you were saying that this draft of this rule doesn't actually allow for investment in law firms as it's drafted. Is that right?
That is correct.
Okay.
Maybe this will help a little bit. And so this is a professional conduct rule trying to protect the public from bad lawyer conduct. And so the conduct that's encompassed by this is the broad field of fee sharing and partnerships with non-lawyers. But it doesn't live in isolation. It works in concert with other longstanding regulations that aren't just lawyer conduct regulations, but they're police power laws to protect the public. And the key one is unauthorized practice of law, where the courts, including the California courts, have said the practice of law is a lawful business only for a law firm or a lawyer and not for a non-lawyer. And so the UPL laws effectively restrain the non-lawyer investment if the non-lawyer investment, passive investment, is intended to provide a return on an investment so that you're profiting from a practice of law activity. And so with that in mind, this 5.4 proposal that Professor Moore has was looking at it in terms of, here's a lawyer law firm setting where the practice of law is attributed to the lawyer and the law firm, but there's some participation by non-lawyers. And there's a bracket over around the 25%. We set out a table in the last agenda materials that told you that their percentages are different depending on the jurisdiction you're looking at. But because that percentage element, it's still considered a lawyer, law firm activity engaged in the practice of law, but you've opened the door or a creek to let the non-lawyer participation to a certain percentage come in. I still think you might have to play with the UPL prohibitions even for that, but this is supposed to be a different type of reform or solution to the problem. The entity regulation that Leah says we're going to talk about later, because it's coming out of some of the other subcommittees, is a more direct reform of the UPL restrictions. It's saying we're going to create an exception to the prohibition against the unauthorized practice of law to set another regulated entity or certified entity go out there and practice law and reap the benefits of that. And that is separately a different type of reform that can be done. It can go through the risk-based regulations to see what laws need to be applied to make that happen. But again, with the menu approach, is there a version of a 5.4 where the practice of law is kept within the confines of lawyers and law firms that this subcommittee wants to propose that the full task force put out with the board's permission for public comment? Because it is a way to get there. It doesn't have to be paired with entity regulation or necessarily with a UPL exception. ABA Ethics 2020 thought it might be a way to go about it. So I think we can at least explore it. But it is something that would be a different way of getting to the same result. It's not as robust or as aggressive a solution, but it's one solution. I think Professor Moore said, and Mark Tuff said it before in his subcommittee, that we might be looking at baby steps to get to where we ultimately want to go, and maybe a 5.4, which is within the judicial branch of which the state bar is an arm, is one step that can be taken. Maybe it's something could be even done on a shorter time frame than a full-blown entity regulation, where some of the questions is who's even going to be the regulator.
Thank you for that clarification. And I think some confusion here is that we keep saying 5.4, but we have a 5.4, and that's we're sort of comparing and contrasting this proposed 5.4B, but as it still stands, Rule 5.4 does regulate all of this stuff. But I do see in the proposal here that the proposal would be that it open it up to a lawyer may form a entity with individual non-lawyers. So the proposal that's in our materials would exclude entities, but that are not law firms or lawyers, right? But Rule 5.4, as it currently exists, excludes everything. So this is a carve-out, but only one piece of the carve-out. It's an individual carve-out. Does anyone have questions about that? I know I was confused. Andrew?
Yeah, Professor Moore, maybe you could help out a little bit. I have a question about the specific language of the proposed 5.4. A6 says a lawyer or law firm may share legal fees with a non-lawyer or with an organization that is not authorized to practice law if the lawyer or law firm complies with the requirements set forth in paragraph B. And the first requirement in paragraph, does that mean 1 through 6 and not B itself? Because B says a lawyer may practice law in a law firm in which individual non-lawyers in that firm hold a financial interest. So it seems that if you look at B plus B1 through 6, it would exclude an organization that is not authorized to practice law, because that doesn't seem to come within the scope of B. Do you understand my question?
I see perfectly what you're saying, because the issue is in A6 refers to a non-lawyer or with an organization that is not authorized to practice law.
Yeah, so I guess my question would be, under what circumstances would a lawyer or law firm be able to share fees with an organization that is not authorized to practice law?
Okay. And
because it
here-
doesn't
The
seem
system
that
has
that
detected that a minimum number of lines are connected to this conference. Do you want to continue your meeting? Press 1 to confirm. If there is no response, the conference will end.
That's the teleconference for the public. We want to keep it live. Let's keep it live. Yeah. So we need somebody to dial in there. Because if the system is saying that nobody's really there, and does the system want to, do you want to shut it off?
We can keep going. I think the point is following the money, right? It's not necessarily following the firm, it's following the money. Is that what you're trying to say, Andrew?
Okay, I think, I c-
I'm not sure, since the system isn't detecting anybody else called in, I think you guys can keep going until I get someone to call in.
okay.
So we're still live. It is being streamed, so public access is not denied because our phone line went off.
Let's have Professor Moore answer this question. If you're ready to answer, or if you want lunch, we can take lunch first and then come back to it.
Let me try and answer.
Okay.
It seems like the language "or with an organization that is not authorized to practice law." The intent of the rule, and I'll have to go back to the original ABA Ethics 2020. Let me look at that. So I'll come back with a fuller answer. But the intent of the rule was that it would be the individuals, that this was not about investment at all. This was not intended as investment. When it was presented to the ABA House of Delegates, it was emphasized repeatedly that it was not intended to be investment, to permit investment, or to be a full-blown multidisciplinary practice proposal. It was a much more limited proposal. So let me take a look at exactly how they drafted it, because it seems that you really don't have to say anything about or with an organization that is not authorized to practice law, because all that would do is repeat the paragraph A. And that may have been my mistake, because I may have just taken the prohibition in paragraph A and moved it down into paragraph B. So I think that was my error.
Okay. Yeah, the proposed rule looks like it would exclude MDPs because B1 says the firm's sole purpose is providing legal services to clients. And in any kind of MDP, you would usually have other services being provided to clients also. So I read this as totally excluding.
But in this, okay, but in the sense that you could still have a partnership. If, let's say, you practice antitrust law, you could still have an economist, not just on staff receiving a salary, but a partner in the law firm that is providing it. Or you could have a social worker who is sharing in the profits from each individual cases on which that person works. Even though they're not a lawyer, they can share. So yeah, it's not multidisciplinary practice in the sense that you don't have, you're not providing, say, accounting services separate and apart from any legal services that you provide. That's the point of this particular proposal.
So this is more directed at employee compensation or 1099 contractor compensation? Because
I wouldn't say it's 1099 contractor because this contemplates that the person would be
employees.
Would either be an employee or an owner, a part owner of the firm, would have an ownership interest in the firm, but not an investment, not just, a passive investment. You have to actively participate in the delivery of legal services. That's how this was presented.
Okay.
And I think that, and I'm pretty sure now that you mentioned, I'm pretty sure I just took the language and talked about, I added or with an organization that is not authorized to practice law in A6.
Okay, just for the record, I think I would be in favor of proposing this change to 5.4.
Which change?
The one drafted in this memo, rewriting 5.4B and adding 5.4A6.
Okay. And again, it would just be one of a number of proposals because I think the other groups are going to be proposing one where it's just going to be, you don't even have to have lawyers necessarily involved. This would just be an organization that is providing a technological solution to the provision of legal services.
Maybe this would give the public an additional option if they want to comment on something that is a more limited enlargement of the scope than...
Yeah, or in Mark Tuff's word, a baby step.
Baby step.
Ellen and then lunch.
Would it be helpful to maybe take a quick vote to see where people stand on this proposed change? Like now?
Now, is the vote going to be, do you agree with the change or do you agree with sending it out for public comment? Because that's what I think we were.
Don't we have to do both? Like, or are they really separate? Well, because I'm with Andrew, for what it's worth, I also agree that, I'd be comfortable with the proposed language.
Has everyone read the proposal with all 7 bullet points?
And there would still be some issues that we should probably clarify that are mentioned in the footnotes, but we can do that after lunch.
It's a gauge to see where we're at.
Okay. So is there anyone who, raise your hand if you have not read all the bullet points that we're talking about? Okay, seeing no hands. Raise your hand if you're in favor of putting this proposal as written, although we may take another look at it after lunch.
It can be a concept.
The concept of this proposal.
To permit non-lawyer ownership in law firms to deliver legal services.
So the concept of using the proposed revision of 5.4. I'm not going to be able to repeat it the way he did. All in favor.
If I might add, to permit non-lawyer ownership but not passive investment.
Okay, non-lawyer ownership but not passive investment. All in favor of this?
So I think we need to do a roll call because we had a change in attendance.
Okay. And just to clarify, that's not to say that we won't also have a proposal for investment. But they might be 2 separate proposals. Go ahead, Mia. Here? Yes?
Yes.
Present. Yes.
Are you, I think we're...
Is this the vote or
the vote.
It's a roll. So we're voting. Yes. Sorry, I thought we were doing a roll again.
Yes.
Yes.
Okay, so let's go eat, and then when we come back, I'll just ask if anyone has any more comments about this rule as written, so maybe take another look at exactly what it is, in case we have anything to add before we move on. Okay. So, okay, good, it's working. So just to give you an outline about the rest of our session, we have about 35 minutes. So Professor Moore and I would like to just wrap up our talk about the proposed 5.4, because there's one provision that we did not address that I think that we need to. And then we'll get that homework assignment out for someone to write up the pros and the cons of our proposal so that we can present it at the next meeting. I think that's the correct process, but correct me if I'm wrong, please. And then we're gonna save the more in-depth talk about regulating firms until tomorrow. I do want to hear what our group has to say about it, because it may or may not be what everyone else is presenting on, but I can tell that there's going to be a lot coming this afternoon, so I think our conversation will be better after what we hear what they all have to say. And so then I'd like to, after we go through the new 5.4, I'd like to go through the suggestions that cont'd made, and so we can address their suggestions. I just want to make sure that if they listen in, that they know that their suggestions have been heard, some of which we've already gone over today, and just kind of evaluate their suggestions for better or for worse.
Tara, before we get into all of that, can I ask if we maybe take one more vote on what I'd really love to, if the rest of the committee is down for it, I'd really love for us to present both the revised rule as Professor Morris has started to put it together and whatever changes are made, and one that's just shooting for the moon, right? Like the fee sharing's allowed, as long as you maintain professional independence and client gives informed consent. Would the subcommittee be willing to put forth both of those items for public comment? Because I think it could be really informative to the court and to the task force and to all of us on whether lawyers really are worried about their professional independence and whether they have, those same concerns we've kind of talked about a lot here. I think if the rest of the subcommittee feels that way, I think it would be very informative at the very least.
Well, my question to the leaders here is whether it should be a separate proposal or whether it should be a interrogatory, as they called it earlier, an interrogatory to the underlying proposal. What would you think about making this even more open? Is there any thought, or is that something we should discuss at the group level? Randy?
I'm not sure this one would work as an interrogatory to the 5.4 amendment, because I think it really would have to be paired by an abrogation of UPL. Because when you completely wide open it, then that includes the passive investment, and includes the more than 50% ownership, or even 100% non-lawyer, very small lawyer involvement. You have employees participating in a profit sharing plan as an employee of a non-lawyer entity, that sort of thing. Then I think it could be a standalone.
Can we table that portion of it until tomorrow when we talk about UPL?
Tomorrow, so my vote won't count. So, but if that's what the subcommittee wants to do, I'm fine with that.
Only because it does involve. Well, we don't have to make a decision on it today. So let's just.
I think my only ask was, would the subcommittee feel comfortable voting on whether to propose a very wide open suggestion for public comment? And I don't know that we need a ton of discussion on that. Are we cool with presenting that to the public or not? But I don't want to take away from your thoughts on that. I think we're going to spend a lot of time talking through the 5.4 rule as it is, and I think that's really helpful, and we're going to tailor that. I think the wide open doesn't need a lot of discussion. It is what it is, and see if the public's willing to. My thought is I just would like to propose that the subcommittee suggests the wide open for public comment so we can see what people say.
At an equal level.
At an equal level. I don't, if you think that needs a bunch of discussion, then I'll shut up.
Well, let's just take a vote on whether we are in favor of it, and if we're not, then we can discuss it again later.
Could I just say something right now? I'm not adverse to adding that to the list of things on a menu. But I really need to think about it a little bit more. Like when I woke up this morning, it's not something that I would have felt like voting in favor of. Hearing the approach we're taking, that it's going to be more of a menu list of things, I just wouldn't want that to detract from everyone. I just want to think just a little bit more, because we're going to have to identify the pros and cons, and I'd like to spend a little time identifying the pros and cons before we have a vote as to whether we're going to be putting that out. I know I'm really not trying to be an obstructionist. It's just, to me, it would be a huge step, and I just need to step back just for a little bit.
And I agree with that, only because we do need to come up with the pros and cons, and that's going to include identifying the other maybe obstacles to implementation and the other pieces of it. That's not to say that we can't start putting those thoughts to paper in our drafting as part of the homework assignments, and then taking it up at our next meeting.
Could I make, since we're going to be meeting tomorrow, that doesn't mean that we couldn't perhaps meet by telephone, perhaps, between now and the June meeting. And would it make sense to try and plan for a tentative date now that where everyone would be able to attend?
Yeah, that makes sense. Lori, does that work for you? Okay. And I think let's go for a phone meeting in between, I think. And what day is the next meeting? Oh, it's the end of June. So something in early June would give us enough time to notice it, to put thoughts to paper, and then to notice our conclusions before the next meeting. Is that correct? Mm-hmm. So
is any day of the week particularly good for people?
No. I'm going to just throw some dates out there. June 3rd, June 5th. Professor?
June 3rd is better for me than
Another Monday, okay.
Yes, but it's by phone.
Right.
Monday at, I want to say 10 a.m. Pacific time is midday for you. And does that work for the State Bar? Okay, so June 3rd, and they'll circulate for us any information that we need for call-in, and we'll say 10 o'clock Pacific time. 2 hours?
If it's going to be by phone,
Mm-hmm.
well, we can always go longer.
Okay, so no, we can always go shorter.
It's just that we have to begin, I think if I'm not mistaken, we have to begin at 10.
Mm-hmm. But we can always go longer. But we can always go shorter.
We can't begin before 10,
Mm-hmm.
but we can go
11,
beyond.
So let's do 10 to 1, but we can always end it early. I think that'll work. That way we don't feel cut off. But I mean, I think long phone calls are hard to monitor and tiring, frankly.
And remember, what you'll have to do is let the State Bar know at least 10 days beforehand where you're going to be, so that they can notice the location.
Okay.
For every individual?
Yes. You can go to a public place.
No, I'm going to be in a phone booth in Santa Ana.
Okay. So turning to the proposed 5.4, I'd like to direct everyone's attention to subsection 5, which is up on the board. And it says, the non-lawyers have no power to direct or control the professional judgment of a lawyer. I think we all agreed that that is appropriate. and the financial and voting interests in the firm of any non-lawyer are less than financial and voting interest of the individual lawyers holding the greatest financial and voting interest in the firm. I feel like that can be rewritten just to make more sense. The aggregate financial and voting interest of the non-lawyers does not exceed 25% of the firm total, and the aggregate of the financial and voting interest of all lawyers equal to or greater to the percentage of voting interest required to take any action or for any and all approval. First of all, I think it's complicated, and I hope that we can start simplifying laws. But the second issue is this, the aggregate financial and voting interests of the non-lawyers does not exceed 25%. Professor Moore, do you want to address what we discussed on that?
My suggestion is that we change that to 49% for now.
My suggestion was going to be 50%. Currently in District of Columbia, that's they offer a similar. I don't think it's a rule, maybe it's law. I don't know the appropriate term, but I happen to know two people who are not lawyers who are 50% owners in a law firm out in DC, and there are several examples of this working successfully. So I would say 50%.
So the way this is, and I agree, Tara, the writing on this is really confusing. And if I'm a non-lawyer who's looking to do this, I get totally lost in the words. Is this saying that all lawyers in the firm, I think I'm a little confused about the wording around the aggregate of the financial and voting interests of all lawyers in the firm is equal or greater than the percentage of voting interest required to take any action. Can we simplify that for me so that I understand what we're talking about? Are we talking about 50% lawyer or 51% lawyer interest total versus 49 or 50 non-lawyer? Or are we saying that every lawyer in a law firm needs to own more than any non-lawyer? I'm a little confused by that wording.
Well, it's talking about the aggregate, so it would be the total of all non-lawyers. Ownership interests in the law firm shall not exceed, is what that phrase is referring to there. And then when it says, in the aggregate of the financial and voting interests of all lawyers in the law firm is equal to or greater than the percentage of voting interests required to take any action for any approval. That last clause is there, I think, is just to ensure that any action that is taken, that there will always be, that before any action is taken, when a vote on particular action that's going to be taken by the law firm, is that there has to be a majority of lawyers present. Because that goes to the heart of the concept of independence of professional judgment, and that it's the lawyers who are ultimately responsible for making the decisions in the law firm. We might be able to come up with a way to say that more succinctly and more clearly, with less ambiguity or vagueness, but that's essentially what I think is the intent.
And I think we should endeavor to do that in our drafting. I mean, I think this should be a point unto itself. Non-lawyers have no power to direct or control the professional judgment of a lawyer, period. And then the next point, so I guess it should be 8 instead of 7. And then the next point should address that the aggregate, and then maybe even voting and financial be separate, because the way it's written is just so convoluted that the financial interests of the non-lawyers, well, I'm not going to say it any better, but the financial interest of the lawyers must outweigh the financial interest of the non-lawyers, and the voting interest of the non-lawyers must outweigh of the lawyers must outweigh the voting interest of the non-lawyers. Am I stating it correctly, or the principles correctly?
Yeah, I think essentially that's what the Ethics 2020 Commission was trying to accomplish, to reassure the lawyers. Remember, This was a proposal that was to go before the ABA House of Delegates, made up entirely of lawyers who belong to the American Bar Association, and they're trying to make that decision. The commission was well aware of the negative response that the multidisciplinary practice proposal received about a decade earlier. So they're trying to make this a little bit more palatable and a little bit more reassuring to lawyers. It was ultimately, if I'm not mistaken, it was withdrawn before consideration. I think they saw the writing on the wall that it wasn't going to be approved, and ultimately was withdrawn. I'd have to go back and look at the results. There were a lot of other, there were, I think, 6 different proposed business forms that they were looking at in their alternative business structures. And they ended up just saying, we're not going to propose anything right now. You have our issues paper. We don't think they're going to succeed, essentially. I think they heard back enough from the going around and talking with people at the meeting. They got such negative reaction that it just never went anywhere.
Andrew?
Not to get too far into the weeds with corporate law, but I suppose B5 would apply to both shareholders and the board of directors if it's a corporation. So whatever percentage you have, the lawyers would have to be majority shareholders, but you would also have to have a board of directors that observes the required percentages also. I wonder if it wouldn't be easier to just...
Okay.
Do you want to respond to that first?
Just to respond to that, we'd have to look in and see how law corporations, how they're comprised and how they're how they're run, because this is referring to a law firm, and a law firm can be a law corporation as formed under the statutes of California, as opposed to just a regular corporation, I think, if we're talking for profit.
Yeah, I think a regular corporation can't practice law in California.
Correct.
It would have to be a professional corporation or I think a law cooperative, and there's a couple of other more obscure corporate forms. But would it be easier to just make a statement that says something like, you know, in the controlling interests of the entity are held, you know, in a majority by one or more lawyers, rather than getting into percentages and voting interests? If the intent is...
That made way more sense.
I mean, I understand the intent here. The intent is to preserve the professional judgment of the lawyer by not putting them in a position where the controlling interest of the entity is held by non-lawyers, and then the lawyer might be, you know, outvoted with regards to, you know, issues of providing legal services. So I think that control can be preserved in a more succinct way. And maybe it would just take some massaging of the language a little bit.
Okay. Let's think about it. I like that idea to simplify it. Once again, I'm a little bit hesitant to change it, you know, getting down in the weeds. What we're trying to come up with is just the general outline of a proposal. Remember, a law firm ranges from a solo practice all the way up to you know, several thousand lawyers practicing in a single entity. So we're not just talking about a law firm like where the DC rule applies, is going to be applicable primarily in situations involving relatively large law firms. They're going to have a lot of lobbyists involved in practicing, a lot of whom are already lawyers, former members of Congress and so forth. They come in and they work in the law firm. I'd like to look at it. I've written down what you've talked about. You know, the controlling interests are held by one or more lawyers. I like that. That might simplify it substantially. But I don't think we have to go so far right now for what we're going to present.
No, I don't think we have to, but I think we should, because I know we're not supposed to wordsmith here, but I do think that it's important, because part of the problem that most people have with California laws is that they're impossible to understand. I didn't understand this. It took us, 10 minutes of a room of attorneys and educated people to figure out what this was talking about. That's not fair. So I do think we should, I know we're not supposed to, I can't help that. I think it's important that we wordsmith so that we present our clear intent, which is unambiguous to attorneys and non-attorneys.
Okay, why don't we just end it
But
with
we can
a
do that
period
homework.
after the fourth line, after the word firm. If you look at the fourth line where it starts, financial and voting interest in the firm, period.
Yeah, that works. And I do think it should be separate. I think the non-lawyers have no power to direct or control the professional judgment of a lawyer. That should be a period. And then the financial or voting interest should be a second sentence. And I like what Andrew said.
And I agree with Tara. I think separating those two ideas would be really helpful to helping all people understand these. So I'm with you on that.
I'm also imagining possible comments to that, because it's more than money or voting. But if you are in a business with a non-attorney, and that non-attorney is doing intake and deciding which clients to take in, they may have been given a role where they are directing and controlling professional judgment, even though they technically have less financial or voting power in the entity, and could, I think, then still run afoul of these rules.
And while we're kind of talking about, I just wanted to think about Rule 4 or Section 4. I don't know if I feel strongly enough about this to go all out, but it seems to me that having a section that says the law partners in the law firm are responsible for non-lawyers to the same extent as if they were lawyers under Rule 5.1. If we're looking for adoption, I sense that could be a place where we actually have a lot of this. This may have been one of the reasons this rule had such a hard time passing. And if we're going to insist that lawyers hold the majority interest, then I'm not sure we need that section. It feels like overkill on just on my end of things.
Yeah, I think that's there to remind lawyers that they have responsibilities already under Rule 5.1 and 5.3. In other words, you don't want to talk about them as non-lawyer assistants under Rule 5.3, but they are supposedly co-owners with you, but you still have an obligation to supervise their activities to make sure that their activities conform with the law. I'm not sure that that's something that we can take out of the rule. I think that's an important point that needs to be there. That yes, lawyer, this is an opportunity for you. It may be financially beneficial for you to enter into these types of arrangements. But ultimately, since this is a provision of legal services to legal clients of yours, the other folks are just going to be assisting you in providing those legal assistance. Ultimately, you're going to have to be responsible for their conduct.
So is that part of the rule? One of the things I'm reminded about is how much time and energy we spent on a comment to a rule in the beginning of our subcommittee to help lawyers understand what they already had the ability to do but weren't sure because the rules confused them or felt they were risk adverse in applying the rules maybe. So I guess my first question is, does 4 change any existing Does it either prohibit more or provide more obligation? If it's just pointing out what already exists, I would be against us continuing to remind
It's not
lawyers.
what already exists, because first 5.1 concerns the duty of managerial and supervisory lawyers to appropriately supervise the conduct of subordinate lawyers. If it's a non-lawyer, it's not covered. 5.3 talks about non-lawyer assistants, and these are not non-lawyer assistants in the strictest sense because they're also owners. So just to make sure that that doesn't fall between the cracks and an argument can't be made later that, well, they're owners, they're not really non-lawyer assistants, so 5.3 doesn't apply. This is a sort of a reaffirmation of a lawyer's duties.
Randy?
I suppose, Kevin, in theory, that might not be the only way to skin the cat. You could also go into 5.1.2.3 and make appropriate changes there, because that's where a lawyer would look for supervision. And that's where the black letter would say the supervision duties with regard to non-lawyer assistants, or in 5.1, the establishment of procedures in a law firm to assure compliance with all persons. You would clarify it in the supervision rules to say that includes co-owners who are not lawyers. But I don't know if we need to complicate it by, because I see what you're saying. We get this on the ethics hotline all the time. They're saying, oh, I have a supervision responsibility? I thought it would be in 5.1, but no, it's in 5.4.
It must be a special responsibility.
Yeah, so I think that's another way, but I don't know if I would endorse that. I think it works just as well here as long as it's in the rule proper and not in a comment, because it is a new duty.
Yeah, and I think my preference would be to keep it here in 5.4, because you're looking for a duty to supervise, but the any lawyer who is involved in any kind of a practice that is going to be regulated under Rule 5.4 is going to be looking primarily to 5.4 for guidance on what their duties are going to be. So I think it's better to put it here. Or if you do revise 5.1 and 5.3, you then keep this here, but then you just change it and say, recognize you comply with your duties under 5.1.
So I have one more proposal, which is what we talked about earlier. So for the non-California or non-attorneys, just the state bar has to approve your entity. So if you do a professional corporation or you have a LLP, you have to submit that information to the state bar, who reviews it and makes sure that if you claim to have multiple offices, you do have multiple offices. If you claim to be a partnership, there better be more than one attorney. If you're a law group, then you must have some staff. So to that same end, I think I propose another point here, which would be, 8 or 9, whatever we're on, that requires what we discussed earlier, was that the individual be approved by the state bar with a background check, fingerprinting, and that they as an individual be approved. And my reasoning for that is, going back to the who's risk averse and who's not, is I think that it's unfair to have a business partner who has no repercussions, who can run your law firm into the ground, maybe by making bad decisions, and then go next door, partner with another attorney, and start all over again. And I think that if they as an individual have been approved by the state bar, and that their good standing is required to continue to operate as in this law firm setting, that they will be more thoughtful and not reckless in decision making, knowing that if they violate the ethics rules that they've agreed to, that they can't just go start a new law firm partnership. But I do welcome your other thoughts on that.
That feels a lot like attorney protection and not consumer protection. So I think my first question is, are we sure that in terms of protecting the consumer, the lawyer is a majority holder? And if lawyers are, I'm just not sure how I feel. I don't think I have any problem with the idea of registering with the state bar. But anything past just a simple registry to make sure you say who you are, I think, again, we're not talking about lawyers engaging lawyers. We're talking about lawyers engaging non-lawyers. And what that looks like and who that could be and how they're set up and what they're going to bring to the table, the more we regulate that, the less likely we are to invite people to be a part of this, which means we're going to really limit anyone who can be a part of that. So I would just encourage us to not think about what's fair to the law firm, and instead think about, can the lawyer who's a majority holder maintain enough control in their law firm if they have the majority interest? And if the answer is yes, maybe we don't need much more past that.
Well, just to clarify, my maintaining that it would protect the consumer by just giving them an additional obligation such that by being registered and by remaining in good standing with the state bar, if they start misappropriating funds or taking other, negative action, that they would not then be able to go and create another one of these law firm entities. So it would be to protect the consumer, not just to protect the firm, but to add that additional balance that they're also obligated and that they won't be able to continue in this type of environment if they don't, not meet all the criteria, but the general ethical obligations.
Tara, I'd like to respond specifically to your comment. I'm not opposed at all to regulating non-lawyers in some way, but that's, I think, outside the scope of 5.4. The language in this proposed 5.4 is there because it contemplates a system where the only people that the state bar can regulate are lawyers, which is the way the current system operates. So I think within those confines, it does kind of the best job it can of holding the lawyers accountable for what the non-lawyer owners of the law firm are doing. And then if we want to separately regulate non-lawyers in some way, that would have to be part of, I think, a separate regulation scheme for non-lawyers that might also encompass things like, entity regulation of, non-law firm entities and things like that.
That's fair. I don't like it, but that's fair. Any other comments to that? We can add that back to our agenda for tomorrow and our phone call meeting when we talk about non-attorney entities. Okay, so I think for homework, Professor Moore, can you wordsmith the proposal that we discussed?
I'll revise it. Randy, will there be anybody here tomorrow to assist us?
Yeah, Mimi and I will both.
Oh, cool. Okay, good.
Email it to us tonight, and then we can have it ready to go tomorrow.
I might not. All right, I might do it in the wee hours of the morning. So, but no, you'll get it before. I'll email it at latest in the morning.
Randy, do you want us to email that to you and Mimi or to ATILS?
Just copy ATILS, but send it to Mimi and myself, or even just to Mimi.
Okay.
To make sure, because she'll be the one.
Okay.
Let me mention one thing just real quick. And
yeah.
so to the extent this contemplates non-lawyer ownership in the context of a professional law corporation, there are rules of the state bar approved by the board and the Supreme Court that govern the process by which a law corporation is certified. And one of the rules, 3.157, does provide that the shares of a law corporation must be owned only by that corporation or a shareholder. Shareholder is also defined, and a shareholder of a law corporation must be a licensed and entitled to practice law. And so there would have to be some sort of conforming change if the state of California were to allow a professional law corporation as the format for this non-lawyer ownership entity, then there would be conforming changes to the law corporation.
So technically, you could have a non-entity partnership and that would conform without any changes?
I'm not sure if you're talking about a partnership that's not a limited liability partnership, just a general partnership. I don't think the law corporation rules or the LLP rules stand in the way of that if you change this rule. But if you become a limited liability partnership or a law corporation, I think the licensed persons regulations for those might get in the way.
Okay, so it'd be possible, but really not so much practical without that second change.
Yeah, I'm just not sure what the business format is the preferred business format for a law firm these days. I think a lot has changed since the Professional Corporations Act was first issued. Used to be that was the go-to format, but I almost think limited liability partnership might be more popular.
Mhm.
Are any of those requirements in statutes? Or are we just talking about state bar rules?
I'd have to check B&P code and the Professional Corporations Act to see if the licensed person, I think it's expanded there to include, you can be a lawyer anywhere as long as you're active, but it might have to change to say a non-lawyer if you have to conform your articles of incorporation also to the Professional Corporations Act.
Mhm. Okay, so really quick, we only have a few minutes before everyone else comes in, but I would just like to turn to the court buddy suggestions.
Tara, before we
Yeah.
do that, I think Alan made a suggestion about 50% and Professor Moore made a suggestion about majority.
Kevin Moore's good.
I only refer to you as Professor Moore in my head, so I don't know that we actually established which is which, or which as a subcommittee we're on board with. So can we talk about that for a second?
Sure. What were the two options? One is 49% and one is just a majority. I mean, I think we're.
I'm sorry, I think it's 50%, 49%.
equal.
Yes.
Yeah,
yes.
so you're an equal.
Okay, but I thought we were going to end that provision before we get to identifying the percentage.
I think we were just going to go with majority. So it could be 50.1% ownership. So it would not be equal. It would be majority, I think was what we.
So is that the majority decision of the subcommittee? I think that's what I'm asking, because I'm on the 50% board, and I'm just wondering what everybody else is on.
Should we vote? What's the procedure here? Do we vote?
I think we can have a vote, but just if everyone would take a look at paragraph 5 or B5, and what I think was proposed, and this is how I was going to revise it, and I maybe find out, but might as well clarify it right now. 5 would simply state the non-lawyers have no power to direct or control the professional judgment of a lawyer, period. And then a new paragraph, subparagraph B6 would be the financial and voting interests. We haven't decided yet. I'll draft it in the alternative, split up the financial and voting interests. But then it says the financial and voting interests in the firm of any non-lawyer are less than the financial and voting interest of the individual lawyer or lawyers holding the greatest financial and voting interest in the firm, period.
I guess I'm just asking to talk about the concept. I want to make sure we're all on board with the concept and then adjust the rule instead of talking about the rule and then adjusting the concept. So for me, the question really is, are we as a subcommittee only willing to go 49% for non-lawyer? Are we willing to go 50% and just no more than
Let's just
equal
take
shares?
a poll without a formal vote or anything. Raise your hand if you're in favor of 50-50. Raise your hand if you're in favor of majority. Oh my God, it's a surprise. I never would have guessed. Shocker. Let's just draft them both and then put it out to the committee.
Okay, and the one last point I'll make before we all get back together again with the full task force. If you are going to impose a duty on lawyers to be ultimately responsible for the conduct of the non-lawyers in the firm, I think that in all fairness, there should be a majority ownership before you can impose that.
No cake and eating
duty
it
on
too.
them.
It's a great way to protect the lawyers.
Well, there's a reason they're the only ones doing it.
And you non-lawyers will always have a shot if they works with the UPL AI folk who are going to propose that you just have an entity providing legal services without lawyer ownership interests at all.
Right, but and I think that's the point, is that once again we're talking about a different type of structure.
Yeah, I think what we've been looking at, and one, we're looking at increasing access to justice by providing lawyers with the technology to better assist their clients. And the other is, well, let's cut out the lawyers and just go full bore technology that I think it was referring to as client facing type, provision. And those are sort of like the two branches of the river. I mean, as we course into the future.
Yeah. Well, and the
Or-
third, which is an entity that requires lawyers, but isn't only lawyers.
Right, but no, yeah, I mean, but this is sort of like that. But this is emphasizing more of the lawyer being assisted by technology as opposed to the other alternative, which would be just straight technology, client-facing solution to the access to justice problem.
So for tomorrow, we will then look at the court buddy rules real quick, even though, will you be on the phone, Lori, at all? No?
I'll see what I can do. I've got a flight at 11 and I couldn't move it, so
Okay.
I'm not sure. I can try to call in though.
Okay.
That probably makes me a public member though, because I'll be
Sure.
a public member if I am.
Okay. And then, so we'll talk about court buddy, and then we'll recap everything that we discussed, or that we will be discussing at this session, which will be, I think, UPL and law firm entities.
And you'll have a copy of the revised rule and the court buddy, so you could always, during the public comment period, you can make your comments. And we could get into a debate with you as a member of the public. And then as soon as you're on your plane, we'll take a vote.
So wait, is there actually a proxy? Can I do that?
No.
No. Okay, it was worth a shot.
going to get started, folks. We're going to actually start with a roll call because I think our composition may have changed slightly since this morning. So, Mimi, why don't I ask if you would please take the roll call? See?
All right. Justice Edmond?
Here.
Toby Rothschild?
Here.
Joyce Raby?
Here.
Andrew Arruda? Simon Bomi? Tara Bird?
Here.
Judge Wendy Chang?
Here.
Abhijit Chavan?
Here.
Jean Clausen?
Here.
Johan Drolshagen?
Present.
Margie Estrada? Lori Gonzalez? Bridget Grammy? Andrew Kuchera? Joanna Mendoza? Kevin Moore? Heather Morse? Daniel Rice? Alan Rodriguez? Daniel Rubens? Mark Tuft? Angelina Valverde? And Joshua Walker.
Present.
Thank you.
Hi, Joshua. Welcome.
Thank you so much, Your Honor.
Okay, we are going to start out with asking again for public comment, just in case someone has joined the call and wants to weigh in with a public comment. And hearing none, we are ready for the report out about what went on in the discussions of the separate subcommittees. We're actually going to start with the ABS MDP.
So we're going to split up the reports, and in the materials you'll notice there were 5 recommendations, so we will, not necessarily in the order you saw them, but we will have different people reporting out on different pieces of it. I guess for the record we should note that there was a public member who joined us for the subcommittee meeting who was very helpful in passing on additional information. So let me start with the recommendation 1, and which is Joanna.
Yes. Okay, thank you. The first recommendation of our subcommittee, which was unanimously approved, was that lawyers in traditional practice and firms will stay under the current regulatory framework with a mind towards expanding access through innovation. The pros with that is that it's been working with respect to regulating lawyers, not particularly the best with regard to access to justice, but we would continue to encourage pro bono efforts, and technology innovations could be adopted through or by attorneys to improve consumer services, and it would be a complement to adding entities to the regulatory scheme. The cons were that so far it hasn't worked particularly well with access to justice, but that's what everything else is hopefully going to improve. We do have a limited number of lawyers and dollars to go to legal aid, so everyone fully agreed with this. That's the extent of that report.
The question is how you want to proceed. Shall we vote on each of these as we come to them, or should we go through the whole thing?
I think we should.
Randy?
I mean, that would be my thought, because there might be someone who would vote on one, but
Yeah.
not the other.
Yeah. All right, so
I would.
I guess the question is, are we going to discuss each of them?
Why don't I make a motion to approve this recommendation by the task force? There's a second, and then we can move on to discussion. Is there a second to approving this recommendation?
Yes.
Number 1, lawyers in traditional practice and firms will stay under the current regulatory framework with a mind towards expanding access to justice through innovation.
I don't know. I'd kind of rather hear the list of things, just because I don't know what that really means as compared to what, or do we just take it alone?
We're open to doing it, presenting all of our recommendations and voting on each one separately at that point. So if...
Maybe just sort of an introductory overview of the 5 points,
Yeah.
and then dive into each one.
Sounds good. All right, so there's number 1.
There's the introductory overview of the first one.
Okay, and then number 2 and 5.
Okay.
Jean?
So the over
introductory of recommendation number 2. Recommendation is to widen the scope of our charter to include entities which may or may not have lawyer ownership or operational management and control. Some of the considerations where we came to this recommendation, we really looked to the Legal Services Market Landscape Report, and where it discussed ethics rules today, and any business engaged in the practice of law must be owned and controlled by lawyers, which really talked about the prohibiting limits, both the opportunity and incentive for non-legal entrepreneurs to enter the market, and that by modifying the ethics rules to facilitate this close collaboration of lawyers and non-lawyers, that the legal profession will accelerate the development of one-to-many productized legal solutions and drive down overall costs, improving access for all classes, improving predictability and transparency of legal services, and aid the growth of new businesses which elevate the reputation in the industry of the legal profession and serve really the broader needs of society. This recommendation is also provided that an entity is authorized to practice law is subject to the appropriate regulatory standards and can be held accountable by an effective enforcement system requiring lawyer ownership or management, which would not necessarily add additional public protection, and where there are ABS reforms that involve some percentage combination of lawyer and non-lawyer ownership. The subcommittee is not aware of any strong empirical evidence that the legal tech for consumers has prospered. Some of the other considerations to this recommendation, that some percentage of lawyer ownership and management is regarded as a key to assuring minimum level of competency and independence in the professional judgment in any context where legal services are provided to clients. And that today there's currently a lack of empirical data indicating that this would demonstrably increase access. So that is our presentation of recommendation number 2, which then also kind of segues into recommendation number 5. Recommendation number 5 states new models being proposed would include individuals and entities working for profit and would be limited and would not be limited to not-for-profits. We added that part, kind of tweaked it. In that consideration, we also looked to the same report, the Legal Marketing Landscape Report, under existing rules and regulations are a disincentive for non-legal entrepreneurs to enter the market space today. And the subcommittee believes that individuals in the middle class have access to justice concerns that could be addressed by the activities of a new form for for-profit providers. Some of those considerations that we also discussed, that a study of regulatory reforms is to use technology to create access to justice for persons who can't afford legal services under the current delivery system. The traditional model that prioritizing legal tech development in the not-for-profit context would be the most direct route for accomplishing this directive, but it is not clear that legal tech innovations developed in a for-profit sector would have significant trickle-down benefit to legal service organizations and the persons served by those organizations. So that is everything that we considered as we put this forward, and so that is recommendation 2 and 5.
And 3 and 4, Bridget.
Okay, this is kind of a lot of information at one time, I feel, but anyway, we came up with these 5 recommendations, and then that we would like you all to vote on that we're talking about now. And then there are some things that I'm going to talk about where we are still discussing as a subcommittee the way it's actually going to work. So what we're asking the task force to do today is to vote on the general principle, and then we're still working on the structure of it, just to give you a little preview of what I'm going to say. So our recommendation number 3 is that entities can be we would have entity regulations, and that the entities can be composed of lawyers, non-lawyers, or a combination of the two, but the regulation would be required and may differ depending on the structure of the entity. And then this recommendation number 4 kind of goes along with this also, which is that non-lawyers will be authorized to offer limited legal services as an exemption to UPL with appropriate regulation. And the reason that we're putting these two together right now for you is because it really just is in the context of delivering legal services through entities, and that these entities who may be delivering technology or legal services through technology may be utilizing non-lawyers to deliver these services. And so we're just trying to get these big principles, out there. And then the actual way that it will work is something that we can go into more detail in. So basically, we've come up, when it comes to this entity regulation, is obviously a really big overarching structural change. And so we identified, is this working? Yeah, okay. We identified some overall principles that we all agreed on as to the way the regulatory structure would work with regulating entities. And then we came up with, right now we've come up with 3 different options basically for a way that a regulatory structure could work. And before I go into that, I just want to know, do we want to vote on the other ones first, or do we want to do you want to hear everything that we have to say about all 5 recommendations and then vote? I feel like it's hard to kind of take all of that information in at one time when you're, does anyone care?
We run through all 5 recommendations.
Okay.
Right? And then let's go back to 1.
I think that makes sense. Before I go into the details about
Yeah.
kind of what we're thinking, okay, I think that makes sense. Okay, so let's go back to 1.
So again, number 1 was that we are recommending lawyers in traditional practice and law firms stay under the current regulatory framework with a mind towards expanding access to justice through innovation. So it's fairly straightforward.
Yeah, there was a motion.
Okay, so Joanna moved that recommendation. It needs a second.
Somebody.
Okay, it's been moved and seconded. Discussion. Randy.
So now that you've heard the introduction, not to put too fine a point, but the reason for this number 1 recommendation is that when you're talking about possible entity regulation, new standards for entities occupying the practice of law space, and you're even talking after that about, well, what would be the regulator? Would it be the state bar or something else? That dovetails well with this idea that if we're going to allow entities to practice law, and we might have a new regulatory construct for it, what happens to a traditional practice, which is an entity, a law firm that's incorporated? Well, we're not trying to upset that apple cart. We're just saying all of that traditional practice of law corporations, for now, stays the same. And the new stuff is all going to add access through the new regulations and the possible new regulators, et cetera. And so that's why I think this is part of this package of 5 things, just to keep it clear what's actually being proposed out of reform. We're not saying we're going to completely move the regulation of lawyers to the Department of, Consumer Affairs, anything of that sort. We're going to keep law firms and the traditional practice right where it is.
Would somebody please explain to me the scope of what you mean by entity regulation? It's, in other words, one form of entity regulation that I'm familiar with is law firm regulation, as in New York and New Jersey. I suspect that you mean a lot more by entity regulation, and I'm wondering if you could perhaps give not a precise definition, but maybe give an overview as to what you're talking about, the scope of what you mean by entity regulation.
Well, we'll get into that a little bit more as we get into the further recommendations. So for this particular one, I think we're just trying to reiterate that we don't want to change the way that lawyers are currently being regulated. But with respect, just to answer your question, though, you're right. We are talking about alternative business structures and entities that are corporations that would be delivering legal services in addition to law firms. So I can talk a little bit more about what that would look like in our other recommendations. But with respect to this particular one, I think we're just looking at affirming for the group that our recommendation is to maintain individual lawyer regulation the way it is. I think is that.
And so in that respect, law firms that are not in this new space that we're talking about would continue to be regulated the way they are now. It would be law firms that perhaps bring in passive investment that might fall under the new entity regulation structure that we're talking about. But as they currently stand, which they don't allow anything like that, we're talking about leaving it as is.
Okay, thank you.
Just on the justice through innovation, innovation of what? Innovation can mean lots of different things, but I know right now we're focusing on innovation and technology. So I would just say you might need to be a little bit more specific there.
Did you want to, I mean, is it fine as it is for purposes of the recommendation, or do you want to change the recommendation to add it?
I would add it because right now innovation can mean anything. Yeah, it doesn't have to, right now we're talking about innovation through technology, but innovation period can mean anything. And you might want to bring it back to the technology.
Joanna, are you okay with that? Is the subcommittee okay with that?
Let me confer with my counsel.
So one of the things that we talked about was not narrowing the scope so specifically to leave innovation open just by the nature of the word. So maybe something to consider is by saying innovation inclusive of technology. So maybe adding it that technology is included, but not making it so narrow and niche, because it would be hard to serve the purpose of innovation if you are going to isolate it and then create another recommendation for anything excluding technology, if that makes sense. So I would recommend that through innovation, inclusive of technology. Did that address?
I mean, I think that's fine. I think the point really is more focused on the beginning part than the end part for as far as the substance of this recommendation, which is just that we want to keep things as is. But I understand. I'm just looking past you because I'm looking at the words. I mean, I think that's fine to clarify that. I just think just to reiterate the point of this number one is really just that we want to keep things, the existing regulation of attorneys through the way that we are as individuals right now.
And to the extent rules changes are being discussed, the rules changes, I don't know that they're actually going to be limited to only technology applications. So changing the rules is innovation. And since we are I'm assuming that the task force will ultimately recommend some rule changes, that would fall under this expanding access to justice through innovation.
Before we move on and discuss the details of the rest. Okay. Mimi, do we need to do a roll call vote? Okay.
Just innovation. All right. Okay. Andrew Arruda, Simon Bomey, Tara Bird, Judge Wendy Chang, Abhijit Sivan.
Yes.
Jean Clausen. Yes. Johan Drolls-Hagen.
Yes.
Margie Estrada. Lori Gonzalez. Yes. Bridget Grammy. Yes. Andrew Kuchera. Yes. Joanna Mendoza. Yes. Kevin Moore. Heather Morse. Yes. Joyce Raby. Yes. Daniel Rice. Toby Rothschild. Yes. Alan Rodriguez.
Yes.
Dan Ribbons. Yes. Mark Tuft. Angelina Valverde. And Joshua Walker.
Yes.
Thank you.
All right. Number two.
Number two, second recommendation, widen the scope of our charter to include entities which may or may not have lawyer ownership or operational management and or control. Do we make a motion to approve the recommendation number two?
I'll second.
You made the motion, Jean?
Correct. Yep.
Okay, Hammond's been second.
I know you guys are still working out the details, but is the idea with it, these other entities having a mandatory requirement to become part of the bar as you move down this idea?
I'm sorry about this process because it's hard to explain it all. So we are still working on the regulatory structure and the way that it's going to work. So for purposes of this specific recommendation, what we're trying to get, the heart of what we're trying to get to is that we as a group, if the task force is open to this, is open to having an entity that may not be owned by lawyers only, or that may not be in the majority owned by lawyers only. We're trying to broaden the idea here to expand the concept that there could be a technology company owned by non-lawyers that are delivering legal services. And as a subcommittee, we voted that we are good with that. And so that's really, for purpose of this recommendation, that's where we are. And then when it gets to my part about number 3, like the actual structure, I can tell you the way that we're talking about the different ways that we're thinking about doing it. But again, we as a committee haven't decided exactly, and that's why we want your feedback when we get to that. And I know it's hard to take it in chunks, but right now the concept is just, are we good with having non-lawyer ownership even in the majority?
If I can add to that, I think there's 2 words missing from the recommendation, and that's task force. Well, it should be widen the scope of the state bar's task force's charter, not the state bar's charter, because this subcommittee was assigned to ABS and MDP, alternative business structures, multi-discipline practice, and those traditionally have been known to just be not as broad as what we are proposing. So we wanted to make sure that the charter went beyond ABS and MDP to include all these entities for consideration. So that's friendly amendment. We accept. Okay, it's the task force's charter that we want to amend, not the state bars.
Further discussion?
Yeah, I have a question, and if you could please clarify, because in the memo that's dated April 29th that goes with this, you quote Professor Henderson, who talks about by modifying the ethics rules to facilitate this close collaboration of lawyers and non-lawyers. Yet you're talking about that this may or may not have lawyer ownership or operational management. So on the one hand, what seems to be supporting in the pro, you're talking about lawyer input, cooperation, and then you're saying, well, they don't have to be involved at all. So what is it? What are we voting on? Because if there's no lawyers involved, my inclination would be to vote against this.
This is just expanding the charter. When we're putting forth the principles that we are believing need to be in the regulations, there will be some level of lawyer involvement. It may not be operations, it may not be ownership, but there will have to be some sign-off by attorneys. So, but that goes more into the details. This one is just expanding the scope so that we can look at that issue. And so when we go down to 3, that talks about more of the details, 3 and 4, that's when we talk about where lawyers don't need to be there and where they must be there.
So, Joanna, can I just clarify, or Jean, I think you are suggesting modifying the last sentence of subparagraph 3 of the charter. Is that where you're looking?
You could use the word consideration instead of include or address.
How about include? It would be essentially including but not limited to.
Well, I'm just asking because
that sentence talks specifically about permitting non-lawyer ownership of investment in businesses engaged in the practice of law. And so when I first read your recommendation, I thought you were adding lawyer because the charter already talks about non-lawyer.
I don't know. The problem is when we were given our assignment, it felt limited to not allowing consideration of a purely non-lawyer entity, and how that would be encompassed, and we haven't dug down into operations versus ownership yet as far as the regulations themselves. We just wanted to make sure we're given as broad a brush as possible to look at everything so that we can really provide a fully fleshed out recommendation one way or the other. So as far as actually how you'd wordsmith 3, I'm not really, we haven't attempted to do that. We just wanted to make sure it was clear that we could look at these things so we can present some arguments for and against.
Are you talking about entities that don't provide legal services, or only entities that provide legal services? Well, in the charter and in the amendment. Because I'll just point out that it appears to me that the charter encompasses non-lawyer ownership, even total non-lawyer ownership of entities, as long as they're entities that are engaged in the practice of law.
I think part of the problem is what is the definition of the practice of law? And then, so that could be limiting in itself. And so I do think it would be delivery of legal services, which could be broader than just the practice of law. And we just want to make it clear. I think, I apologize, I misspoke because I was starting to get into my own recommendation, which was number 3, but the number 2 part in expanding the charter, I think we just really, as Joanna said, I think we just want to be clear that we want this to be on the table as an option for us to consider as the non-lawyer ownership beyond just, I don't think you could have non-lawyer ownership of an entity that is practicing law per se, because then you don't have lawyers. I don't know.
I think some of the subcommittees might be discussing just that.
Okay, I know. This is why it's also overlapping.
Could I make a recommendation rather than saying that the recommendation is to expand the charter, but that the recommendation is to have the task force confirm that the charter already includes this? Because I think how most of us are reading this is what you're looking at is already covered.
Yeah. Yeah. You okay with that?
Yeah.
Yeah. I'm okay with that. As long as we have the same interpretation of.
Yes. Okay. Further discussion. Mimi is taking a shot at rewording this. No.
That's just notes.
Yeah. Oh.
I mean, are you guys still gonna vote on this? The motion, can I try to confirm that?
Maybe we can wordsmith.
Okay, you want me to wordsmith? You want to wordsmith this to make sure that we're then?
I think Professor Moore had it.
Just if you could scroll up just a tad to the original, just instead of saying why.
Wait, in the scope.
Charter, just say confirm that the scope of the task force's charter includes.
Yeah. Perfect.
Okay. Thank you. Kevin? Further discussion? Everybody ready to vote? Mimi?
All right. So the motion is to confirm that the scope of the task force charter includes entities which may or may not have lawyer ownership or operational management and or control, just because Josh wasn't on here. Okay. Andrew Arruda, Simon Bomey, Tara Bird.
Yes.
Judge Wendy Chang. Yes. Abhijit Shaban. Jean Clausen. Johan Drolshagen.
Yes.
Margie Estrada. Lori Gonzalez. Bridget Grammy. Andrew Kuchera. Joanna Mendoza. Kevin Moore. Heather Morse. Joyce Raby. Dan Rice. Toby Rothschild.
Yes.
Alan Rodriguez.
Yes.
Dan Rubens.
Yes.
Mark Tuft. Angelina Valverde. Joshua Walker.
Yes.
Thank you.
Jean, you want to address 5 now?
Okay, yep, we'll go to 5. Thank you. So recommendation 5, new models being proposed would include individuals and entities working for profit and would not be limited to not-for-profits. Do we have a motion to approve recommendation 5? Second?
Okay, it's been moved and seconded. Discussion.
If what we're doing here is to try to encourage innovation, it doesn't make any sense to limit it to nonprofits.
Okay, then everybody ready for a vote?
So the recommendation is that new models being proposed would include individuals and entities working for profit and would not be limited to not-for-profits. Andrew Ruda. Oh, sorry. Simon Bomey. Tara Bird.
Yes.
Judge Wendy Chang. Abhijit Shaban. Jean Clausen. Johan Drolshagen.
Yes.
Margie Estrada. Lori Gonzalez. Bridget Grammy. Andrew Kuchera. Joanna Mendoza. Kevin Moore. Heather Morse. Joyce Raby. Dan Rice. Toby Rothschild.
Yes.
Alan Rodriguez. Dan Rubens. Mark Tuft. Angelina Valverde. And Joshua Walker.
Yes.
Back to the. Oh, sorry. Joshua, did you vote?
Yes, I said yes.
Okay, thank you.
Thank you so much.
Thank you. Thank you, Your Honor.
Back to the subcommittee. Are we going to number 3?
Yes. Okay. So this one, the way we have it worded now is that entities can be composed of lawyers, non-lawyers, or a combination of the two. However, regulation would be required and may differ depending on the structure of the entity. So, and then this is where the regulation and the way that it will look is something that we're still trying to figure out and are wanting to talk to you about and get some of your feedback on. But we are asking for a vote, at least as to the very broad principle of the recommendation itself. So just to give you a sense of some of the things that we've talked about as overarching principles, one thing that we have been considering is this concept of a risk-based regulatory approach in which whoever regulates these entities would be taking a look at what the risks are to consumers with respect to these entities that are delivering legal services and identify a set. It would probably be maybe legislatively set or maybe set by court rule where these regulatory objectives would be clearly set out. And then the regulator would be able to be a little bit more flexible in regulating these entities with all of these objectives in mind, instead of the way we typically regulate now, which is by saying this, you can do this, you cannot do this, and being very prescriptive as to the approach. So that is like an overarching principle that we all are generally in consensus about as a principle. We haven't like dug into exactly which ones they would be. Some of the other principles that we discussed is taking into consideration the California Justice Gap study that comes out and identifying where the particular gaps are, both in practice area and geographically, and then finding a way through this entity regulation to incentivize companies to deliver legal services that would address this justice gap. And so we talked about, for example, with licensing fees, these entities would be charged licensing fees. depending on, if they were actually addressing one of these gaps and they were developing services to address one of these gaps, maybe they would pay less licensing fees. Or if companies just want to go out and, work with the Big Four or do some kind of profit, they could do that, but then they would pay an additional maybe assessment that would go towards the funding of legal services, so that we could ensure from the outset that this regulatory approach would be addressing the justice gap. So these are just some kind of big principles that we talked about. Some other ones that we talked about just as a group that we all agreed on was that the regulated entities would have to maintain confidentiality and avoid conflicts, just as individual attorneys are bound to do. The entities must agree to keep information and data confidential. The entities would not be prohibited from, must be. Must be prohibited from selling data acquired from clients or potential clients. Entities must be required to place the needs of clients above shareholders. So this is always, this independent judgment thing. And non-lawyer employees of regulated entities may not represent clients in court. These are some things that we all agreed on as a whole. There were some other things that we didn't reach consensus on, but other topics that we discussed, such as entities would be permitted to provide any legal service except litigation or advocacy, trying to just, and like the UK model does, which they reserve certain activities for attorneys, but then try to make it otherwise broad. So we talked about litigation advocacy as, a reserved activity, but then other things such as maybe transactional document drafting of certain types could be okay. Entities would be permitted to identify and assist consumers in completing applicable legal forms. They could offer hybrid legal/non-legal services to clients. And then another thing that we talked about was something that they're talking about in the UK is more price transparency. So requiring entities to post their prices. We didn't reach a consensus on this, but these are some of the things that we've been talking about. No one disagreed, but we didn't, I don't know why that wasn't listed in there. Anyway, I think it's an interesting thing because we've talked about the perception that you can't afford a lawyer is very much driven by the fact that you have no idea how much it's going to cost you at the end of the day. So having this transparency could be something that we could address through the entity. The other thing, just as a general principle that we've talked about, is tracking data from the very beginning. So if we are, as a condition of receiving a license for an entity, they would have to be reporting certain information so that we can be sure from the outset that we are addressing the access to justice issue and that we will have this data going forward. So that is that. Then we got into who would regulate the entities and what would this look like. And this is where we've come up with kind of 3 ideas. And they're not fully written out for you. 2 of them are we put in memos. One of them we just talked about today. So I'll just talk to you about them. The first one is the idea of just maintaining it within the state bar. So basically the state bar as a regulator would continue its existence, but then there would be like a separate division, almost like the Committee of Bar Examiners, where there could be a separate, like board that would make the recommendations and would do the regulation, but it's all part of the existing structure of the state bar. And again, it would be paid for, the enforcement and everything would be paid for through licensing fees of the entity. Another approach we talked about was an independent board altogether, like the Legal Services Board. And that would be really separate from the state bar and potentially, I don't know, we talked about it could be a judiciary branch agency still, but maybe subject to sunset review from the legislature. We would try to maintain its independence in some sense, but it would be a separate board that would oversee the entity regulation and I think also the regulation of individual non-lawyers. And then a third option we talked about would be to have a separate independent nonprofit entity to regulate the entities itself. And it would be like on a nationwide scope. So this would be, it would be like an outside organization altogether. And then you would have to have the courts of each independent state would have to like delegate authority to regulate entities to this organization, then if you comply with this organization's requirements, then you would be allowed to practice in that particular state. Does that make sense? Do you want me to explain that more? So those were our, just very briefly, but those were just kind of the three different ideas that we had for the way that we could regulate this. And we really haven't dug into, well, if you're a non-lawyer entity, then here's exactly what you have, the criteria that you have to meet. But we did definitely say, if there are not lawyers involved, then we would have to ensure that, from a consumer protection standpoint and based on these risk-based regulatory objectives, that consumers were still being protected in some way through the regulatory process.
Can I ask a question on that? Yeah, how would the state bar or even California promulgate such a nationwide regulation or regulatory effect?
So the state bar would not do a nationwide. So are you talking about the third option?
Correct.
So it wouldn't be the State Bar of California. It would be an independent nonprofit altogether. And each state, including California, so in this case, it would have to be the Supreme Court, I would think, would have to agree somehow through, a compact or something, to delegate the regulatory authority of entities to this entity, and basically would permit any entity that is licensed by this independent group would be permitted to deliver legal services in California. And so that group would have to get specific permission from each and every state in order to operate in that state. It's kind of like a compact idea. Does that answer your question?
I think so, yeah.
Okay.
Okay, Kevin and then Joyce.
Okay. My question was really, I guess it kind of follows a little bit on what Joshua was saying, but where does the Supreme Court fit into this, where you have an independent agency when the Supreme Court is charged with regulating the practice of law in California? And I understand you haven't gone that far, but when you start talking about an independent agency, does the Supreme Court consent to having some other agency do this? Have your discussions gone that far?
Yes, and so again, these are three different options, and that's one option. And under that option, yes, the court would have to look at how this independent agency or entity is set up. I use the word entity, and that's confusing. So say it's called entity, I don't know what it's called. It's not the ABA, but consider it kind of the way that the ABA accredits law schools, just to get a model in your head. But it would be, or almost like medical, legal, like medical specialization boards. They have this board and they determine what you need to do to be a medical specialist. It would be like that there would be this independent board agency. That agency would make these the criteria for regulating entities. I think the Supreme Court would then have to look at that independent agency and say that it agrees or it disagrees that it's properly protecting consumers. And if the court agrees that, yes, the way that this regulatory framework is set up from this independent agency, then the court would, I think could be by court rule, would agree to delegate its power to regulate to that agency, or to at least permit entities to deliver legal services in California if they're licensed by that entity. But I think the court would have to definitely make that determination. I mean, we couldn't just do it without that. Yeah. Do you want to? Yeah.
So, what prompted I'm just trying to understand a little bit of the why. So we've got a couple of different options, two of which clearly kind of fall within the current regulatory structure, would be relatively easy, given these things relatively easily, being a generous description of how these kinds of things happen. But I mean, and then we have this other thing that's really quite complicated and political and could, long term and whatever. And I'm just curious,
just to better understand your thinking behind that. Like, what was it that prompted you to think that a national solution might be a better way to go?
Well, I will let Jean answer as far as, why don't you answer first and then we can talk about, okay, never mind. I'll go first and then I'll let Jean answer. So I think we talked about this at the last meeting, but there was an ATILS meeting in Denver where we talked about entity regulation, and there's been this paper proposed by Jillian Hadfield and Lucy Rica, and Lucy was the public member that came and participated today with us, where that's what they propose, is having, it's definitely out there, and it would definitely take a very long time, and whether states would ever agree to it, I don't know, but that is what they propose as a way to allow entity regulation. So that was one thing, and we have that paper. If people want to read it, we can distribute it. But Jean had also independently recommended it. So
yeah, I think too, just putting checks and balances in place and breaking out of the confines of what exists today. So really doing what Bridget referred to earlier, more risk-based regulation versus role or entity-based regulation. And so it's looking at part of this is modeled after kind of the start of what some of the things that they're adopting or attempting in Europe, but then also it's the ATILS report is also something that the state of Utah is looking at and considering right now too, that there's a national entity regulator. And so instead of, businesses trying to conform or entities in each and every state, business is global now. And so something needs to be set in place where companies can operate nimbly, but still meet the protection of the consumers in all of those different geographic regions, practice regions, rural areas, so all of the different needs-based type legal needs and being able to funnel up and be regulated by a national organization, which also then lends credibility to individuals and consumers, where they're also not trying to understand why it's different in every state, if that makes sense.
If I may, this is a great model. The adoption rate on these things is through the roof and faster than almost any other regulatory model that's out there right now. You can look at the American Medical Association, American Psychiatric Association. Right now, I'm actually working with a program to bring all the surrogacy providers in the country together. These are really fast, really easy charters to put out. And even if there's a competition between a couple of entities doing this, they tend to absorb each other really quickly and then just keep doing business. So kudos, absolutely.
I do think it would be very difficult to get the state Supreme Courts to sign on to something like this. I think it would take a really long time to do that, but
And everybody is still subject to the local jurisdiction as well as the local laws, so that doesn't go away at all. It's actually it's not a 501c3, but it's a professional membership association is essentially what they call it. And just being a member or not being a member, this is the endorsement model that we've discussed, as opposed to limiting or regulating. You can literally say that we want everybody in the state of California to be a member of this. We like their standards. We'll approve of that. As long as they've got some supervision, they'll still be subject to the laws and supervision within the jurisdiction. Plus, you tend to get not only state but local chapters involved. So you actually are using peer pressure much more effectively than you would be just passive regulation.
So I had a follow-up question. So I'm assuming when you say the adoption rates are high, you mean the service provider's adoption rate is high. And I'm curious if you have, or if you're also saying that states are quick to participate in some. There's the current existing regulatory structure. How quick is it to participate in something like this versus the for-profit organizations being like, yeah, we'll abide by whatever the standards are or whatever and get this endorsement? I'm assuming when you say adoption is quick, you mean the service provider side.
No, actually, I mean it on the state side. It becomes turnkey. Like if we had a model where we had ODR going on, which we do around the country, but we had an association of appropriate non-attorney arbitrators and mediators with appropriate formatted ODR platforms. The state of California can look at it, turn on ODR for the entire state, have a list of people ready to participate. They can even have online registrations and gaining their membership, as well as online learning platforms and everything else. So the take-up time for the states is shortened by about 90%.
So I wanted to ask a question about the client confidentiality. One of the things that I've sort of kept in mind as we're talking about all of these ideas is the client should have the ultimate say in whether their information is confidential, because I think there are real constraints, both time, energy, money, platforms, when you're talking about requiring confidentiality versus allowing a client to waive confidentiality. I just kind of wanted to throw that in the thought process, because I'm down for everything but the idea of requiring confidentiality, because I don't even think lawyers are required. Well, I guess they are. Professor Moore? Yeah. I think that as a society, we have waived confidentiality in lots of places. And I just think there are some really cool models and ideas that could be built. At a hackathon, they once talked about a jury of your peers, like literally letting people log in and vote on court cases, which I thought was really cool. So just that idea that we may want to consider that being required unless the client waives confidentiality, maybe something like that.
I just want to go back to something Johan said. He said that they're still going to be subject to state rules and regulations. What state rules and regulations? The whole point of this is to create a regulatory framework. There are no state rules or regulations that they would be subjected to with this endorsement model that you just discussed. And I think that's, if it's there, fine, but it isn't there, because if they're not lawyers, they're not subject to the state bar rules and regulations, or the Business and Professions Code. They would be subject to general business statutes, but I'm not sure that's going to provide the necessary protection. So, I'm, to use a term that Lori's been using, I'm down with some of what you're saying. But I'm going to draw the line at this whole federal concept, which I think is just crazy. I mean,
oh, that's so funny. So, but of the two then, of having the bar itself or having an independent, a totally different body regulate, like of those two things, do people have thoughts about the regulatory structure? It's setting aside this third party idea, but if we're maintaining it within California regulation, do people have thoughts about where it might fit in the regulatory structure?
So going back to Lori's comments and also something mentioned earlier, are we talking about clients or customers? Because when we're looking at the purchaser of these services, they're not looking to create an attorney-client relationship. They're, filling out form. There are many things that are going on. So I just think that in that wording, we need to be careful, because it seems that we might be creating an attorney-client relationship when they're really just customers.
And I also think that there's a distinction between when an attorney's involved and when an attorney's not involved. And if an attorney's involved, it should come under the state bar. And one thing we discussed in our group, not that we had a consensus necessarily or didn't one way or another, but that perhaps if it's a non-attorney coming in, that they have some approval by the state bar. And now a suggestion I made was, you have to pass a background check. We talked about fingerprinting, making sure your credit, you haven't gone into bankruptcy for these types of endeavors, and that you can't do that. You can't just drop one entity and join up another law firm when the business fails, but that's probably completely separate than these other products, which may or may not have an attorney-client relationship, or I guess wouldn't if there's no attorney involved. And those would be two completely different things.
one of the challenges we saw with having a whole new regulatory agency created versus the state bar is that they'd be covering some very similar ground, and they might not possibly have the same mission in mind. If you have one agency with one overriding mission, everyone's operating in the same plane. They're all working together for the same things. You have one board oversees all of them, oversees the lawyers, oversees the entities, and any other legal service that we decide might need to come into that in the future. Of course, we'd have to change the name. I have to throw that in there, but the Legal Services Board could still be this, essentially what we know as a state bar now, but the structure is already in place. Our enforcement system is already in place. The competence issues, it all could fit within our existing structure if we just expand it a little bit. I think it would be the easiest way to deal with it without having problems of different missions competing with each other.
I just want to make a quick comment about I saw a bullet point on conflicts. So I could imagine a piece of software that's providing a legal service that doesn't retain data for privacy reasons. And in an example like that, is there a conflict, right? So I would just caution us to, the rules sounded like the rules regulating attorneys, but in the software world, they may not apply for various reasons. So I just want to highlight that.
I just wanted to make the point that under our group, which is the UPL AI group, we are contemplating a sub-agency of the state bar. We haven't thought anything else.
Could you talk a little bit more about your distinction between role-based regulation and risk-based regulation?
Role-based, so they've done a lot of studies around this in Europe where role-based and similarly to when the regulatory authority is your state bar, that you are inherently bringing in the roles versus the risk. So the risk to the consumer, instead of bringing in the traditional perspectives, it's really assessing what is the risk that the individual or person who wants the legal services is willing to take. So it's weighing what is their level of risk that they're willing to take. So instead of protectionism, it's more in the form of informed consent. So it's making legal services be more transparent and allowing that individual to make the decision on the risk. So it's what are the risks in how they're getting the service and what's the service that's being provided, and letting it be nimble versus allowing the kind of the inherent prejudice of the roles come into assessing the risk and coming at it from a protectionism perspective. Bridget, did you want to? Do you want to talk to that?
I think what happens is you agree, I think either legislatively or by the court, but there's a bunch of principles. So for example, consumer protection is something that is a key regulatory objective. You identify what are the regulatory objectives, and that becomes the focus of what the regulator does, so that there's some more flexibility. The other thing that we didn't throw out there, but we've been talking about, is this regulatory sandbox idea. So, piloting this form of regulation in some way, and that you can kind of gather data as you're going and see how it's working, and keeping a close eye on the entities that are delivering legal services, so you can make sure that you are properly addressing the risk, while keeping it flexible enough to move with whatever kind of new risks may emerge in the market, and that the regulator is flexible enough to focus in on those things. So it's really different. I mean, because we were even talking about the discussion of, triple LTs, and what would these, if you're not lawyers, then what would this individual be permitted to do, and what would they not be permitted to do? And that's how this discussion of roles came up. And I do see this in studying other professions, like the nurse practitioners and the doctors, and then the doctors always get very upset anytime that the nurse practitioners want to have more independence from doctors, and there's this whole fight over the scope, and you lose sight of what you're trying to do, right? What the objective is to protect consumers. And often what happens with protectionism is that people say that they're trying to protect the public, but really they're just trying to protect their own little market share, you know? So to try to avoid that by being overly prescriptive, you really hone in on the exact reason for the regulation to begin with. You know, what is it that you're trying to, what kind of market flaws are you trying to protect against to make sure that consumers are adequately protected? And then just see the way that plays out in the delivery of legal services with these entities as it goes, instead of being so descriptive of like, this is an entity, this is the role that the entity will play, this is what it's allowed to do, this is what it's not allowed to do. But that's about as much detail as I can give you.
Yeah, I think we also
want to give some examples, Bridget, from the Denver. So like one of the risks they identified is consumer overpays for legal services. So that's a risk. So what does your regulatory framework do to address that? You require pricing transparency, which we don't have current requirements for lawyers. And you survey your consumers to see, do they understand the pricing schemes that are being assessed? So it's a very different kind of regulation. It's really hard to get your head around because it's not complaint driven at all.
Right. Yeah, that's what I was trying to sort of do in my head, was the back end, right? And think of it as it's not complaint driven, but it's
kind of auditing
to the particular principles on
Correct.
some random basis.
Yeah,
and you can build a matrix around it. So you can say, what are those risk factors? Matrix, just like businesses, you know, kind of value and prioritize their objectives. So that also, those risks matrix can be flexible with the market as well and what's happening with consumers.
Right. So some of just to give you an idea, along with the one that Leah just said, these are the risks that, for the purposes of the discussion at the ATILS conference, they talked about this consumer overpays, consumer purchased a legal service that's not needed or not appropriate to their legal issue. The consumer does not engage with the legal services market at all, which is, you know, what we're seeing. Consumer fails to exercise his or her legal rights because they did not know that they possessed that right. Consumer achieves a worse legal result than they would have had if they used the next best alternative. So those are just some examples of the type of risks, and then you can design your regulatory approach to address those risks.
I think one of the things I have a hard time wrapping my head around with this distinction between role-based and risk-based is, I mean, England had a problem because you've got barristers, you got solicitors, and so forth. We're still going to have lawyers. And so there is still going to be, there's no matter what, there's going to be some level of role-based regulation. But it's just, I think as we're talking about rolling it out to other providers, we're not going to be so stuck in, you know, calling them something in particular.
It's an interesting discussion. One of the things especially for the non-lawyers in the room, the purpose of the rules certainly are to protect the public. That's an important part of the State Bar's mission as well. The rules are also there to protect the administration of justice. So when you're considering the risks of changing a regulatory framework, you need to consider that. So for instance, we have a rule 3.3 that prohibits a lawyer from pressing any cause of action or claim when they're lacking probable cause, and they're doing so just for purposes of harassment. And the reason we do that is not only to protect the people who that particular lawyer or their party are pressing that claim against, but it's to protect the court system itself, so that the court system, the integrity of the profession and the administration of justice is protected through that rule as well. So I just would encourage you, as you think about these risks that you're attempting to address, that you not lose sight of that. I mean, obviously protecting the public is important, but let's not be myopic about it, and make sure that we're taking that into consideration as well. And it's interesting because actually it makes me think of Mark Tuft, who's not here. His voice is always ringing in my ears, but I mean, one of the things I think he would say is, well, what we're really kind of dancing around is the separation between legal advice and legal advocacy. And I think that's one of the things that when you mention how England has dealt with this, when you're dealing with legal advocacy, you're obviously putting the administration of justice at greater risk. And that may be a dichotomy that you want to explore a little bit.
I was just going to ask, do you think the court would be, do you think that feels like part of the risk matrix that you can build, right? I think I actually agree with everything you just said. And I know, shocking. And so, but I think that's just an important thing to build into the risk side of this, because what I'm really loving about this idea is the focus becomes on the consumer and the risk to the consumer, and protections have been the word of the day in every one of these meetings. And what's clear is we don't all agree on what protection means in this setting, because I still go back to, any industry that's not meeting 80% of the need is not really protecting the consumer. So I like this idea a lot. I think it's a really cool way to really focus on the consumer. I appreciated what, and I'm sorry, can't see her over there. Heather, what you said about clients versus consumers or customers. But I also think we have to be careful, because I don't know any clients who don't understand they're not also customers, right? Client is a word we use in the legal field, but the average consumer thinks they're a customer. It's the same thing. So that word can be it's an interesting conundrum, because,
It connotes different things, though, because with a customer, you don't have the attorney-client relationship with a customer. But going back to, and I can't remember your name, and I can't see. Alan, Alan's comments is that there's times where, when you're really interacting with the technology, you're really not creating a relationship, because you're not even keeping the information, and it's, however the information is being stored, depending on what type of forms or whatever process is happening. So I think we do need to be careful there as well, because all of a sudden we don't want to create an attorney-client relationship between, a piece of technology when there really shouldn't be one there.
At this point, while you continue to talk about the options.
That's right.
And has it been moved and seconded?
I will move it. Thank you.
Okay, it's been moved and seconded.
This is for number 3, recommendation number 3, which is entities can be composed of lawyers, non-lawyers, or a combination of the two. However, regulation will be required and may differ depending on the structure of the entity.
Everybody ready to vote on this one? Randy.
I know we're going to get some other recommendations we talk about later, but this one seems broad enough to include what came up earlier in the Rules Ethics Committee Subcommittee, which is the separate question of complete passive investment in an entity or a law firm entity. And so I'm just wondering if this should be construed as an endorsement of passive non-lawyer ownership in an entity that's delivering legal services, what would be a practice of law activity.
I think so. Yeah. I think so.
Yeah.
Kevin.
Microphone.
That's it, okay. And the question I asked then is, how will that advance access to justice?
You mean the second part that Randy just mentioned, or
Yes.
in general? Well, I mean, generally speaking, with respect to ours, and I think that the non-passive, or what do we call it? What did you just call it? Passive investment. Thank you. Non-lawyer passive investment. We talked about ways that we can structure the entity regulation as a whole to specifically hone in on access to justice. So that's something that we're measuring and something that we're incentivizing. But I don't think the way that we're envisioning it, I think it would be a broader regulatory structure, and that we would find ways to incentivize and encourage these entities to address the justice gap, but that would not be the only thing that it's doing, if that makes sense.
Okay, I guess my question is, if I were to vote and say yes, or sure, or why not?
I'm down.
I will not say I'm down. No, I mean, not on this, not on as broad as this. will I be also endorsing the concept of investment? Because that's where I don't really want to go right now. I don't mind you exploring this. If all I'm doing right now is that this is fine to explore, but this is not the final vote on this particular issue. Fine. I don't mind you exploring the possibility, but I don't endorse the passive investment in a law firm.
So then I think we would just keep the motion as is then, for the original motion.
We will be looking at that issue as whether the more full recommendation going forward, but this is just, the threshold question without the specifics.
I have a question about the word composed. Is that the same as owned by?
We didn't want to get into owned, operated, and the distinction between the two at this stage.
Because technically, isn't that statement true today? I mean, you have non-lawyers and lawyers composing a law firm. Should we not specify what it is?
I don't think we're ready. I don't think we're ready. I think that's a question, whether they're owned or operated. Do we want to say owned and operated, owned and or operated, a combination? It's just.
Or what do you mean, like leadership?
I defer to you guys. I'm just a staff person. I'm just trying to be. I'm just trying to help. I'm honestly trying to be helpful because I don't think it's specific enough.
But
I'm just speaking for myself. It's technically a law firm is composed of those three groups of people today.
Could I suggest entities can be composed solely of lawyers, solely of non-lawyers, comma, or a combination of the two? Would that be more clarifying for you?
I don't think that addresses his concern. His concern is that law firms already compose both. It's whether or not we're talking about at what level are we going to be looking at the entity? Are we going to be looking at its officers and directors? Are we going to be looking at its managers? What group are we going to be looking at? And we haven't tried to hone it down to that level yet, because that's going to be a more detailed regulatory question for us to be looking at.
I guess, again, I don't vote, but could you maybe explain what you guys consider the statement to mean or to be saying?
Well, I think that we know that it would likely include for a corporate entity, as an example, your CEO, the officers that are identified in a statement of information. Essentially, you have people you've identified that will be held accountable for what that entity is going to do, and individuals that will be in the database so that if there's a problem with that entity going forward, those people are marked with that issue. When it comes to a partnership, obviously partners. Will it include the actual, if it's a partnership but it's managed by somebody different, is it going to include that person? Again, that's a level of regulatory involvement we haven't looked at specifically. But we have indicated that we'd want the main executives involved with every entity to be identified, either as they already are with the state, or if it's a partnership, which doesn't require that, it would have to be specifically with the bar itself, that you'd have to identify who those individuals were. But these are just ideas that we're tossing out. We haven't really honed it in that carefully. I don't know if that's helpful at all. Toby.
I think that the thrust of this recommendation is to say, what's the broadest possible scope that this could be? So composed could mean the existing construct. Composed could mean ownership. It could mean management. It could mean any range of things. But it's just the broadest possible scope of what this is talking about.
Yeah, I think it's really focused on that second part. Regulation would be required and may differ depending on the structure of the entity. Yeah, so regardless of how that composure is, it's just that we're trying to account for all those different makeups.
It might be that, to clarify, maybe it's regulation, including but not limited to issues of ownership and operation, comma, because then you avoid the plain meaning interpretation that Andrew applied, and you actually are being more provocative because you're saying to the audience, the public comment audience, this is the broadest possible thing, and we're not trying to get ahead of ourselves and determine it. We're just saying we want to look at them all, and it could be different from a law corporation, from a completely non-lawyer owned different corporation.
You all okay with that addition? But not limited to.
I think by way of saying, depending on the structure of the entity, structure implies, I mean, any structure, but if you wanted to narrow that down or put it more defined. So I don't know if there's something that you want to put around that would catch that, but.
Is everybody ready to vote on this? As it appears on the board. Okay.
All right. So the motion is to recommend entities can be composed of lawyers and non-lawyers or a combination of the two. However, regulation, including but not limited to ownership and operation, would be required and may differ depending on the structure of the entity. Andrew Ruda.
Sorry.
That's why. That's my.
You'd have to say including regulations concerning something like that. And I thought it used to say solely in there. I thought that was I thought that was.
It wasn't. It was a suggestion, but it wasn't adopted. It wasn't a friendly amendment at large. It had concerns that it wasn't.
Again, if the idea is to signal to the audience, this is the broadest possible puppy that we're putting out there, solely of non-lawyers, including ownership and operation, it's unmistakable at that point that you're saying, this is what we're proposing that we look at.
So is that language what you're proposing, Randy?
Including but not limited to. Yeah, that's acceptable.
What regulation of ownership and operation means.
Kevin, I'm sorry. What did you say?
No, I'm sorry. I just am not sure what you mean by regulation of ownership and operation.
I was trying to be not sort of biased by using the non-lawyer descriptor of ownership and operation, but you could put in non-lawyer before those terms.
Or could you just put entity ownership, including regulation of entity ownership and operation?
About regulation of entities, including regulation of ownership and operation, comma, would be required and may differ depending on the structure of the entities.
Is that okay? So, regulation of entities?
Or regulation of the entity. Including regulation of its ownership and operation. Would
That's
be required
acceptable.
and may differ depending on the structure of the entity.
Okay, everybody okay with that?
Yes.
Okay. Amy?
All right. Andrew Ruda, Simon Bomey, Tara Bird.
Yes.
Judge Wendy Chang.
Abstain.
Abhijit Shaban.
Yes.
Jean Clausen. Johan Drolshagen.
Yes.
Margie Estrada. Lori Gonzalez.
Yes.
Bridget Grammy.
Yes.
Andrew Kuchera. Yes. Joanna Mendoza.
Yes.
Kevin Moore.
Yes.
Heather Morse.
Yes.
Joyce Raby.
Yes.
Daniel Rice. Toby Rothschild.
Yes.
Ellen Rodriguez.
Yes.
Dan Rubens.
Yes.
Mark Tuft. Angelino Valverde. And Joshua Walker.
Abstain?
Thank you.
Okay, recommendation 4.
I'm going to have to take a train soon, so Joanna's going to take this one for me.
Great. I just learned this.
Well, it's really,
So,
I don't know if it's very,
okay.
nothing else to say.
Okay, there's nothing else to say other than that. See, okay, so this is the recommendation that non-lawyers would be authorized to offer limited legal services as an exemption to UPL with appropriate regulation. It's essentially a subset of what we just talked about, because we already talked about looking at this issue under the prior recommendation. So it's really just being a slightly more specific in that respect. And it could be possibly extended to individuals as opposed to entities. I think that's maybe the biggest difference between the two.
Wait, Joanna, you making a motion?
Yes, sure.
And is there a sec-
I will move the recommendation.
Okay, it's been moved and seconded. Discussion.
Quick question. Referring to non-lawyers, but what about attorneys not licensed by the state of California?
I think that would be considered not a non-California licensed attorney is what this is referring to.
Do we need to
Because
say that?
that's the broadest possible population is anyone who is not licensed to practice law in California.
Okay. So it's just, I mean, just as a layperson reading this and knowing that there are going to be lay people who are going to be participating in this, to me, I'm just wondering is that if you're utilizing, you have somebody from, another state, I mean, are they considered part of the bar? So just recognizing that this regulation is going to be read, interpreted, and impacting people who are not attorneys. So when I look at that, I'm just thinking that these are non-lawyers, not.
Well, again, this is just a broad recommendation. It's not narrowing down who would actually be considered appropriate for this category, what the regulations would be with respect to those individuals. It's just we want to look at this broad scope and then figure out what makes sense thereafter.
Kevin.
Yeah, I think we already have lawyers not licensed in California already covered under the MJP rules of court. So I think this should be limited to people who are not licensed anywhere, who don't have a law degree and have not been licensed as lawyers. That it should be strictly non-lawyers, lay people. Because you're talking about limited legal services.
Lori.
I agree 100% with Professor Moore, and because of what Heather said, the confusion there for the public, I actually really think keeping it non-lawyer versus lawyer helps the public not buy into something they think is more than it actually is.
Could I get a tape of what Lori just said so I can play it in a loop at the next meeting?
She's on a roll. Okay. Any further discussion? Randy.
Limited legal services, I guess it's being used as sort of a term of art in the same way it's used in like the model rule 6.5 or in the legal services community, unbundling, etc. Is that how we're using? Because limited legal services in that context inherently is a practice of law activity. It's not matching services, it's not legal information, it's not document production, it's not self-help. It is a limited legal service, like limited advising at a law school advice clinic. We're actually going to hear your question and tell you what we think, how the law applies.
That's not how we were using it. We were not using it as a term of art.
I think they were using it as limited types of legal service, like a limited amount of legal.
Yeah, it's the scope.
What kind of legal services you can provide.
For example,
Scope,
we
I
all
guess.
agreed with respect to the entities that individuals who are not attorneys would not be representing people in court. Everyone agreed that. And there's some exceptions that already exist we're not touching, but other than that, we need to regulate what would be allowed and what wouldn't be allowed. We're not using it as a term of art that you're thinking of.
But
if
is
you
it
can think of a better way to
practice of
say
law activity? Because if it's not restricted to practice of law, then you can already do legal information, self-help, without being under new regulation. You currently have legal document
We're not
assistance,
talking about
unlawful
things
detainer.
that you can do today without regulation. We're talking
I don't think
about
there's any
things
question.
you
This
can't
was-
do
This
today.
was intended to cover limited practice of law.
Oh, okay. That's
Limited
part of it
by
is-
amount, of, how far you go into
Exactly.
a matter, and limited by what kinds of matters you go into.
Okay.
Further discussion.
The Randys of the world would be confused by it, that's for sure.
Limited delivery of legal services?
So what we're saying here is like a person like me who hasn't gone to law school could help someone out with a matter that's like $500 that no lawyer's ever going to touch. Is that sort of what we're saying?
I mean, again, we're having,
we haven't gone down that
details,
far.
but yeah,
Okay.
if, you know, document preparation through technology, for example.
Okay.
If somebody can put together a way to have that auto fill in after questions being answered, and they're not a lawyer, but it's not just information driven, we want to be able to allow that as long as the risks are appropriate.
Joanna, just quickly, I mean, would they be limited in what they could offer? So for instance, in the motion before, and I can't remember what number we're on, we're saying that, an entity can be composed solely of non-lawyers. So you're saying that there might be services of, that companies comprised of solely non-lawyers would be limited, that they wouldn't be able to offer the same services?
Well, again, we had talked about driving access to justice, solutions by allowing certain areas of the law that where the gap is, allow more entities to come in, and we're also talking here about allowing individuals to come in there. One of the challenges you have is if you have a sole proprietorship, for example, that's essentially an individual. Even if they're running their own company, it's an individual. That's not technically an entity as we often treat it under California law. This would cover that as well, but we're trying not to leave anybody out if it's going to fill the justice gap.
Okay, thank you. I got the clarification.
Toby.
Yeah, I think limited delivery of legal services might be a way to say that, yes, we're talking about more than the, quote, limited legal services, unquote, of Rule 6.5 or other aspects. It's saying we're actually delivering legal services. We're actually providing legal services through a non-lawyer that's registered or licensed or however we're going to end up with the regulation. It might be in an eviction case, because that's an area where there's a whole lot of need that the non-lawyer could. Right now, all they can do technically is fill in the information into the form that the other needs to be filled in, that the client provides, or the consumer, the customer provides. Maybe they can go further than that. Maybe they can make some recommendations. Is you ought to fill this one in. If this is what you want to accomplish, this is how you can do that, but not representing.
Joanna and Jean, are you okay with that language?
I would put the in front of limited.
That works.
Kevin?
Let me just.
I'm agnostic because I'm not somebody that attributes a certain meaning to that term, limited legal services. And apparently there are other people that consider it a term of art, so I'm not that artful, I guess.
Is it you just want to say to offer or to offer and provide?
Provide instead of offer?
Yeah. I think provide is better.
I'd second that. Provide.
Other discussion? Are we ready to vote? Okay.
Andrew Aruda, Simon Bomey, Tara Bird,
Abstain.
Judge Wendy Chang, Abhijit Sivan, Jean Clausen, Johann Drolshagen,
Yes.
Margie Estrada, Lori Gonzalez,
Yes.
Bridget Grammy, Andrew Kuchera, Joanna Mendoza, Kevin Moore,
I'm going to abstain on this one.
Heather Morse, Joyce Raby, Daniel Rice, Toby Rothschild, Alan Rodriguez,
Yes.
Dan Rubens,
Yes.
Mark Tuft, Angelina Valverde, and Joshua Walker. Joshua?
Yes.
Okay, thank you.
Okay, we obviously need to move on. Thank you very much for ABS and MTP for all your hard work. Has somebody been identified to write this up? The summaries of the discussion. Randy, what you were proposing that everybody do is actually articulate the recommendation,
Right.
then tie it back to the charter and explain why it is that this fits within the charter, yeah? And then the pros and cons, and Andrew or somebody, I mean, I guess everybody has already summarized the pros and cons. So
Right.
we just need somebody to tie it to the charter.
Yeah, capture sort of the flavor of the discussion we had here where we clarified what we were discussing. The charter for this one is pretty straightforward, so I don't think it's that tricky. But and then we will use that to develop the public comment report that goes out. We just don't want to lose the consensus that we had in our understanding of what this is before we move on to a lot of other different things. So if one person on the subcommittee is going to be able to capture that before we lose it, then we will have it as we go forward because we'll be talking about a lot of other recommendations.
I don't know that anybody has, but I suppose that the people who made the reports today each could pick up their section of it. So somebody will need to let Bridget know that.
Okay.
Are you sure we just can't assign everything to Andrew since he's not here? He can watch the webcast.
Yeah. And Mark.
The trap for the unwary.
Okay, thank you all very much. Let's move to AIUPL.
This is Abhijit for AIUPL. At the April meeting, we had drafted 6 recommendations. Today, we discussed in depth 3 of them, and we discussed the pros and cons, and we've refined the language of 3 of those recommendations, which we'll be presenting to you today. We've also scheduled an additional meeting for June 7th for us to discuss the remaining 3 recommendations and also a 7th recommendation that we have considered to be added. So with that, I'd like to ask Judge Chang to present the first 2 recommendations.
All right, so I have the first 2 recommendations, and the first one reads, to retain California case law's definition of the practice of law, comma, and do not seek to codify it in a rule or statute. And the reason that we're recommending this is to encourage the uniformity in law. There is a single, well, not really, but there is something that is purported to be a single case law definition of the practice of law. But what you look at when you look at the authorities that interpret it, it is very much applied in a very individual, fact-specific scenario. And that is, some of the case law actually talks about why they do it that way. They want to keep the definition agile enough so it can be, it can address individual factual circumstances that come up, and a lot of times they come up in a lot of different ways. And so we think that that's a good public policy and that we should continue to do that. And so that's our recommendation.
All right, I'll take that as a motion. Is there a second?
Second.
Do we need to go through all 3 like we did with the ABS committee before we talk about each of them individually?
I don't think so. They're individual.
Okay, discussion. Questions, comments?
Could you remind me what the definition is?
Sure. It is the definition. The doing and performing of services in a court of justice in any matter depending therein throughout its various stages. No, that's not it. I'm sorry. Yeah, actually it is. The doing and performing of services in a court of justice in any matter depending therein throughout its various stages and in conformity with the adopted rules of procedure. Now, what you know is we do not limit the practice of law definition in practice to just appearing in court. We apply it in transactional matters. We apply it in a lot of different matters beyond that specific definition. But that is the definition that's in the statute. I mean, the case law, it's Burbauer case. The statute just says, Business and Professions Code 6125, no person shall practice law in California unless the person is an active member of the state bar. The statute does not attempt to define the term.
Okay.
So we also think there's something kind of, I don't think we can fully understand what the implications and the ramifications can be to defining practice of law and what that's going to be on the case law in California. We haven't sat here and actually defined all the cases. And so redefining it can be a very dangerous thing, I think.
I thought in an earlier submission from your subcommittee, you didn't want to touch the definition of practice of law.
Right, we're not.
Then why are you saying retain California's case law definition? Is it even necessary to make that statement? My inclination right now is just to vote no on the record. Is it necessary to even say this for what we're talking about? The ABA looked at this.
So your question is, do we need to make a recommendation of what we're not going to change?
Yeah.
That's interesting.
Among other things, but the ABA tried to define the practice of law and gave up.
Yep.
I mean,
Yep.
they spent a lot of time doing it. And I think that, if anything, in terms of, if we're looking at increasing access to justice through technology, to define the practice of law would be arguably to set up a third rail that is going to just create a hurdle for anyone who is looking to innovate.
It's a good point. However, we discussed this in relation to this phrase in the charter that says, in addition, assess the impact of the current definition of the practice of law. So it was our attempt to refer to this for the recommendation.
Yeah, it's certainly possible to say something like, we do not seek to further define the practice of law. The reason I think it's important to say we're not going to radically change everything is that if the world gets the impression that we're here to sort of throw out all of the rules, including practice of law case law, I'm not saying it's a clean definition, but there's certainly cases around this that we've reviewed, and there were some of the first memos written for our subcommittee. We want to make a point that we're not out to change everything, and I think it's important to say that, whether there could be a more politic or less electric, if you will, way to say that. I think people would be open to that. But I think it is important to say that we're not out to redefine any current case law or traditional rules in this area.
Thank you. Lori and then Kevin.
So I think, hold on tight, Professor Moore. I agree again with the idea of maybe if we reword it in a way that says we're not redefining. From a layperson's standpoint, if you put something out that says retain California's case law definition, as a layperson, I don't actually know how to get to California's case law necessarily, and so I might be less inclined to come in and start creating some new types of services because it sounds really expensive to figure out what the case law has defined the practice of law to be. And so it's a nuanced idea, but really the idea is if there is no change, the more we highlight the no change, sometimes people start to then wonder what is, there's some sort of change in there. I just find that anytime we start tweaking words, lawyers tend to get a little caught up, and then the average layperson is just going to walk away because
I'm
it's not
fine
worth
with
it.
your approach. That's fine with me. Anybody else? Does everybody okay with that in our committee?
I don't know. My thought is just that I'm just not convinced at this point that we don't want to define it or that we don't want to define what it's not. It's just sort of too much for me to approve at this time, because we might find that in separating what attorneys are doing and maybe what some of the non-attorney entities are doing, that we do want to clarify what constitutes the practice of law and what more importantly doesn't constitute the practice of law.
So I don't know if you had a chance to read my memo. I think it was in the second meeting. I did go into detail on what the current law sets out. And it's literally, you have this random list of what is, you have this random list of what not. And you look at it, you're like, if you try to figure out what the lists say, why they say it, it's kind of hard to do. And that's kind of the problem the ABA ran into. And so we just thought we're not going to touch it, because the minute you start putting lists down, you're inviting someone to go against the list. Do you know what I'm saying?
Right, but I'm suggesting that we may want to have a list of what does or what doesn't constitute UPL, so that non-attorneys can look and be like, well, if I'm just doing X, Y, and Z, that doesn't violate UPL. Assuming that we, are keeping the UPL.
So the proposed report language as we've currently have it does have that section of my prior report. It is dumped in, so it does give some context to what the current law says and says not. Doesn't say, says not. Doesn't say.
And I think that this, sorry, may I?
No, go ahead.
I think that this probably needs to be read in context with our other recommendations, and that's the certification of entities, because it's basically saying, okay, here's a safe harbor. Whatever you do, whether it's practice of law under the existing law or not, you'll be fine as long as you get this certification. And as far as the question of, yeah, it might be a good idea to tell people what they'll be, clearly in the green on anyway, but I think that could coexist with this recommendation, because we're saying we're just going to use the current definition, and separately we could make a list of under the current definition, here's what is allowed.
Lori, were you suggesting a revision to the recommendation? You put the recommendation.
I think I'm more along the idea of, this committee is not suggesting, is not redefining the practice of law. I think we just make it very simple. This committee is not suggesting a recommendation. Yeah, thank you. Somebody else can say that better than I did, but just make it very simple.
I've got a suggestion, if I may. How about if we just took out case law definition and put in current interpretation? That way it's not nailed down to case law. California's current interpretation of the practice of law and do not seek to codify it in rule or statute.
I actually like Lori's point about it being more accessible language-wise with her suggested language.
Yeah, I wouldn't know where to find the current interpretation to Lori's point.
Yeah, I think that's part of the issue with the idea of case law is interpretation. So this task force does not make a recommendation to redefine the practice of law. Does that work?
Yeah, if you go down, we have another way of making it easier for practice, like legal process providers or legal providers, and that'll come later.
Randy and then Ken.
So I think Abhijit was correct to refer to the charter, because sort of the background of the charter is that a couple of years ago, the Board of Trustees had a planning meeting in which one of the things presented to them by staff were all of the considerations of these new providers that have appeared on the scene, the AVO Legal Services, the Rocket Lawyers, the LegalZooms, and the board discussed, well, what's the challenges that these new delivery models are facing. And what was presented to them was that a lot of these new delivery models are being attacked on the basis of the unauthorized practice of law. And AVO is now gone. They don't do their legal services anymore. But the perception is that there is a chilling effect because the definition of the practice of law is not codified. And so you can get these LegalZooms and other service providers to flourish if all you do is do that easy thing of writing down what is and what is not the practice of law. You do that, and the way is clear. The Department of Justice won't get in the way of this being anti-competitive. Everything will be free and clear. If you just define the practice of law, and now these other service providers, big green light to go forward with their business model without fear of being challenged by the legal establishment by saying you're encroaching on a practice of law activity. And so a solution that's been thrown out there has this idea is that, well, let's get together and define the practice of law, and that'll fix everything for these other innovative service providers. And I think, the ABA, others have tried it. The MJP report, the initial MJP report from the Supreme Court Advisory Task Force said, we're not going to try that either. It's really a non-starter to try to define the practice of law for everything that's in Judge Chang's memo. And so I think what Lori is saying is correct, that if we're going to assert one thing that we're going to keep stabilized and not disturbed, and that's the status quo with the practice of law. Because some people might think, oh, that's an easy fix. Define the practice of law, and the LegalZooms and everybody else can go sailing along because they know exactly what to avoid. But it's not that simple.
Kevin.
Okay. I think ultimately we'll have something similar to the medical profession. We're not there yet, but with physicians' assistants, nurse practitioners, and so forth, their ability to prescribe and everything. What's off limits and only what doctors can do is pretty much, as was described to me at an ABA meeting about 20 years ago, is cutting. And the equivalent in the legal profession is going into court and advocate on behalf of a client, which is one thing that I've seen has come up repeatedly, that is not going to be permitted. I think that's ultimately where we're going to be headed, that there is going to be a great expansion of the LLLTs, what is it, limited license, legal technicians and so forth will be able to provide a lot of the services that lawyers currently do, just as non-lawyer sports agents provide a substantial amount of drafting and other things that if you're a lawyer, drafting a contract is considered the practice of law. Whereas if you're not a lawyer, you can still draft a contract. So that's where you get into a problem with what is the practice of law. It depends on who's engaging in the activity at any given time. And I understand the conundrum that the Board of Trustees was facing. The only thing that I would change up there of the third motion that Mimi put on it, instead of saying redefining, I would just say defining. Does not recommend defining the practice of law. And then you don't bring in whatever the current definition is, whatever that might be.
All right, Habashi and Wendy, you okay with that?
Yes.
Reformulation of that to say the task force does not recommend defining the practice of law.
Yes.
Yes.
Okay.
I
Everybody
move.
ready to vote?
Oh, we moved. Okay, sorry.
Okay. Mimi.
Andrew Ruda, Sembomi, Tara Bird,
Abstain.
Judge Wendy Chang,
Yes.
Abhijit Chavon,
Yes.
Jean Clausen, Johan Drolshagen,
Yes.
Margie Estrada, Lori Gonzalez, Bridget Grammy, Andrew Kuchera,
Yes.
Joanna Mendoza, Kevin Moore,
Yes.
Heather Morse, Joyce Raby,
Yes.
Daniel Rice, Toby Rothschild, Alan Rodriguez,
Yes.
Dan Ribbons,
Yes.
Mark Tuft, Angelina Valverde, and Joshua Walker.
Yes.
Thank you.
Thank you. Okay, Judge Chang.
Okay, our second, recommendation is to add an exception to the prohibition against the unauthorized practice of law permitting state bar certified register approved entities to use technology-driven delivery systems to engage in the authorized practice of law activities. And so this addresses the second sentence of Charter number 1. The pros are that it provides commercial certainty, which will incentivize innovation and improve services to clients, including those that currently reside in the access to justice gap. It's voluntary, so it allows those who do not want to go through this process, they don't have to. They just don't get the certainty of the safe harbor. It's a controlled rollout of new technologies in the system. And as we are proposing, it will be self-funded by the fee. So the con would be no matter what anyone does, a lot of this is contemplated to go direct to the consumer themselves. And you cannot fully protect against misuse or mistakes. There's just no way to do it. Some people will just not be able to do it, and they simply won't be able to use it correctly. And that is not, there's nothing you can do to avoid that. But that is a con. The second con is that it's a new regulatory scheme. It requires new skill sets that are not currently residing in the state bar, and our recommendation is for this to exist as a subset of the state bar. While it will eventually become self-funding, the seed money for the initial batch of people, because the system's got to be in place for the initial applicants to come in. And that seed money, that's a question.
So just to be clear, I'm not like anti these ideas when I abstain. I know I've been negative, Nancy, today, but everyone else is passing things, so it's fine. I guess, you know, our committee's been taking things on a very different approach. We've been focusing a lot on deregulation, so I'm just not ready today to vote on regulation, which doesn't explain the last vote, but whatever. So I guess that's where I am with here, is that I'm not really ready to say we should have a new entity. We should have a new regulatory schema. I'm more on the side of let's focus on on the regulation we have and how we can expand that rather than adding something new. And that's my concern. But, you know, of course, we haven't had the opportunity to vet it in the same level of details that you guys have had.
Just a short suggested friendly amendment to make that individuals and entities instead of just entities? Or is there a reason that it would only apply to entities?
I think that makes sense. I mean, insofar as, see, I'm using lawyerly words now. Just being around it. Yeah. Okay.
You can have to deprogram yourself later.
As far as a sole practitioner might be an entity, I mean, I think if someone was acting as a sole practitioner, you know, you go to a hackathon, you code something up, you're probably being a sole practitioner in that regard.
Toby and then Lori.
I think one way that when we put it all together, we can address that is to define entity broadly to include a single individual, just as the rules define law firm as including sole practitioners as well as 1,000 lawyer law firms and government entities and legal services programs and sort of any collection or any practice of law entity, and it can be a single person. So if we define entity in the broad sense, then I don't think we have to worry about in every single motion that we come up with defining individual or entity.
Lori?
I think one of the concerns I have about a state bar certification program is not really becoming a part of the state bar. I think there are plenty of entities and individuals who would welcome that kind of certification, but I'm not convinced lawyers are always the best people to really identify risk-based ideas that are really consumer-focused. And so does this contemplate bringing in people who are not lawyers to become part of that process?
Absolutely. So I forgot to add one more thing, and this was going to be our 7th recommendation, but I think it's worth mentioning here. The contemplation is to have a scaled fee system, depending. So, like nonprofits or people, I think there was some in the first group. There was a suggestion about if you're serving an underprivileged area, you can get a reduction in the fee that is contemplated by us.
I'm wondering if we can just eliminate the term state bar from that until we determine as a group what the best regulatory agency structure would be. It captures the same meaning, I think, but without ascribing something, that may be negative to others.
Okay. I mean, I think our contemplation as a subcommittee was that it would be part of the state bar. We weren't thinking that it would be an independent entity.
But maybe we don't want to call it the state bar. Again, there's that hill I'm dying on. But it lends this suggestion that it is a bunch of lawyers, and that's probably not what a consumer wants to think is going on.
But wouldn't the concern is our committee is looking at UPLAI, and so we're concerned that it's a state bar that's going to be coming after someone who is not going after them for the unlicensed practice of law. So this is saying that they would be coming under the umbrella. So that's where we were coming from, and I know that I think there's some nuances of the different committees, but we were really coming at it from the technology company and what they would be concerned about.
So I don't know exactly how this works here in California, and maybe this is one of the reasons why I sort of have this same idea about state bar, but in Tennessee, I actually cannot be a part of our state bar. I sit on lots of committees. I'm shaping all kinds of things in Tennessee, but I actually am not a member of our state bar because I'm not allowed to be as a non-lawyer. And so I understand California may be different, but if we are inviting a lot of different people into this space, how other people perceive state bars in other states is going to matter. So I don't think it's a hill I'm ready to die on. Like I appreciate that the state bar would put this together, but I do think from a perspective of others, understanding we're going to be certified is one thing. Understanding we're going to have to sit in a room like this with the state bar is another. Perception issue.
I think, one idea, I don't know if we have a way to cleanly put this in the motion right now, but one idea is to put state bar led, registration process. So again, I'd still our feeling was to keep the state bar in the driver's seat and controlling the regulation, but we don't want to mean that it's excluding others. I don't think there was any intent to do that. Going to Toby's point, I do think that we are getting to the point where our recommendations are overlapping sufficiently that the subcommittees might want to wrangle and talk together as well. So again, I think we are getting close to that point if we're not there already, and just wanted to reiterate that.
Perhaps we could use the word government because we are a government agency. We're not an association of attorneys, and so we could address the misconceptions out there that way.
Okay, do we know what we're putting there now?
Works for me.
Just eliminate the word bar.
Okay, further discussion. Ready for vote? Johan, I think I saw your hand up at one point.
I was scratching my head.
Okay, all right. Mimi.
Wendy Chang. All right. Andrea Rita, Simon Bomey, Tara Bird.
Abstain.
Judge Wendy Chang. Abhijit Siobhan. Jean Clausen. Johan Drolshagen.
Yes.
Margie Estrada. Lori Gonzalez. Bridget Grammy. Andrew Kuchera. Joanna Mendoza, Kevin Moore, Heather Morse, Joyce Raby, Daniel Rice, Toby Rothschild,
Yes.
Alan Rodriguez,
Yes.
Daniel Rubens, Mark Tuft, Angelina Valverde, and Joshua Walker.
Yes.
Thank you.
All right. Avjit, are you taking the last one?
I am.
Oh,
Yep. Okay, so this one, I'll just read it out to you first. Regulation of an entity permitted to practice law using technology-driven delivery systems must incorporate standards sufficient to provide the same level of protection provided to clients of licensed attorneys, or licensed lawyers, or whatever it is.
As a
Yes,
side,
so the equivalent or better was this is what we voted on. Equivalent or better is what came just after. So there's a slight difference there. Yeah. I think equivalent or better is better.
It's equivalent or better?
Yeah. At least equivalent, yeah. Sorry.
Okay.
Around too many lawyers.
So
Too many
Daniel,
lawyers.
you are moving that, and is
Yes.
there a second?
Second.
Okay, it's been moved and seconded. Any discussion? Lori?
We might have found my first. This concerns me because I think if we're suggesting that entities have to provide the same standard as a lawyer, then essentially you're saying lay people are coming into this space and need to do the same thing lawyers do, and maybe that's not the intent behind it, but that's my first gut reaction. And so that terrifies me. And I think I think it confuses both people who would want to come into the space and consumers who might be buying these services.
Okay, so I should probably start off with some context. So the idea here is to give consumers the same sort of protections that they get from lawyers through the legal ethics rules. And for our purposes, we want to basically take legal ethics rules as they are, make little tweaks here and there to apply it to technology providers, but largely the same rules. Sort of lift it and set it there for legal provider or technology providers. And then also add some additional rules around things like algorithmic accountability, because you can haul a human into court, but an algorithm is a little harder to haul into court, so you need to have some good auditing and things like that. So there are some technology specific things, and what we're really trying to say here is we're comfortable with the sort of existing bar ethics rules and taking those same sorts of ethics rules and applying them to technology companies to affect the same sort of protections. Yes, it's a high bar to meet, but that's what consumers are used to being. That's how consumers are used to being protected.
So I just feel like if I go to my massage therapist because my back hurts, I don't expect to get a surgeon's level of service. And it feels a little bit like a huge constraint on innovation and technology to expect the same or better service from the whole point of increasing access to justice would be to meet the needs that aren't being met in legal. And a lot of that, I think we'll find, is because lawyers aren't meeting the needs, that there's just this huge, I'm not saying this well. Essentially, that feels like we're going to ask technology to come in and do exactly what lawyers do. I think what lawyers do is special and unique and should not be confused ever between a layperson. I never want a layperson to ever think this piece of technology replaces a lawyer. To me, this is, I can't believe I'm saying this, but like the reality is I never want that issue. And I think this type of recommendation does just that. Because if I am required to provide the same level or better level of protection to clients as a client, I may think it's the same thing. It's just very confusing.
Right. So it's not necessarily like in medicine, for example, there's like standard of care. It's not necessarily like standard of care sort of equivalence. It's think of it as just like the ethical duties. So you have like a duty of confidentiality. Well, we're just saying if you're getting a
client
legal
get to
service.
waive that if they want it? Because that's one of the things we talked about. Keeping data confidential is expensive and can be expensive.
Yeah,
and if
it
a
is.
client wants to waive that, then there should be options with informed consent. And so a lawyer cannot waive confidentiality, right? Isn't that, Professor Moore, back me up here?
The client can.
Always.
But can the attorney, once the client waives confidentiality, then allow that information
Yeah,
out
so
there?
that would be similar. And what we want to do is just analogize all of those protections that consumers of legal services have, whether it's, you know, individuals or corporations or other entities. We want them to get the same thing.
Okay, we've got a lot of folks who want to weigh in. Alan, and then Tara, and then Judge Chen.
Yeah, I'm kind of with Lori on this one. You know, I think there's the equivalent. Just I can just drum up all kinds of scenarios where, you know, that's just not going to be the same. You know, again, like the algorithm could destroy part of the value add, could be destroying the transaction immediately after it happens, and so like requiring the software to like run a conflicts check every time. Well, that would require you to store the data to be able to run the conflict, right? So, and I get what you're saying, but I think the other committee kind of addressed this in their bullet points in some of the recommendations. So I would move to strike this as is and maybe instead focus on like being more transparent. So when you use this, you know, this technology, you should know that, you know, it's not the same as like using an attorney. Even this technology has like met certain requirements, that sort of thing. I think just being more transparent to the consumer.
I would say just quick, because I know there's a lot of people that want to talk. We do address a lot of that in the detail of this. We're just saying at a very high level, consumers should get something similar, something that's recognizable to them, and get largely the same protections. How we affect those same protections, it might be end-to-end encryption, it might be tossing the data when we're done. You know, there could be a million different ways to do it, but that's really detailed out.
Okay, Alan, you said you would move something else. We right now have a motion and a second on the floor already. Unless they withdraw it, I think we'll proceed with the vote on this motion. Tara.
Yeah, I'm also in agreement with them, but slightly different reasons. The regulation, again, to me, that word means we're creating a new type of regulation, and I don't think we can afford, frankly, a new type of regulation. We can barely regulate what we have. I might be in favor of a certification process for certain products, but I think that's a slightly different thing, and not what we have before us. And I'm on board with the overall concept of having, you know, utilizing technology. But I think that the way to get there is a slightly different approach. I don't think it's creating a new regulatory structure. I think that it's what our committee was really focused on earlier, and I think what the other committee addressed, which was alternative structures where you have an attorney involved. They're still required to meet the rules of professional conduct, and they utilize technology to better their practice, or, you know, possibly non-attorneys, but that's a separate thing. And I just don't think this directly hits on those points. I think the overall end game is the same. This just isn't the way to get there for me.
So one of the things we were discussing in committee is that if a technology company seeks to practice law, what is the logical reason why they should not be held to the same standards as a lawyer? In terms of the ethics part of it, we're not saying that you are going to be a lawyer, but in the limited space that the technology seeks to take, I don't think it's unfair to say, look, if you're going to act like a lawyer, then you need to be subject to the ethical restrictions that lawyers are subject to up to a point. I mean, how it actually manifests itself is very, very different when a lawyer is doing it or a technologist is doing it. But the reality is, if you are a technology company, you're being used by a law firm now, you really are already being required, because the lawyer is required to make sure that you comply to the ethical standards that the lawyer complies with. That's the current law. So we're going to set up a whole system for technology companies and take that out of it. I think you're potentially upending a lot of the current standards that exist. And I don't see a basis to do that. And in fact, quite frankly, the public does need to be protected. I mean, I don't believe in this buyer beware. If you should just, well, that's not what the State Bar exists to do. And just because we're going to allow the technology, we're going to just put all hands off. I don't think that's right. Because the people who suffer, they're going to suffer. And maybe, yeah, that company that offers a bad product is not going to survive in the long run. But what do you tell all of the victims that got screwed? Excuse me. All of the victims whose cases got all messed up because the technology was bad in the first place for the what? 2, 3, 4, 5 years it takes for that company to fail. How many people have to suffer? How many people have to suffer before we say, okay, you're gone? I just don't think we should be saying that that's okay.
Kevin, and then Joanna, and then
Okay.
Heather.
I guess when I started to ask, I wanted to ask a simple question. What do you mean by protection? What do you mean by level of protection? That's a little bit vague for me. Do you mean the same standards that lawyers are held to, which is what Judge Chang appears to have said? On the other hand, what Daniel said, he's not talking about a standard of care. But in a sense, aren't we talking about certain standards of conduct, which are what you find in the rules of professional conduct? And should they be the same? I'm not sure what is achieved by saying equivalent or better level of protection. I would say just, I kind of like the word same. I mean, it's one syllable.
To go back to what we discussed in subcommittee, the word protection is important, but it is not as global as the word, say, service, right? So if you have a company that's blatantly unethical, right, with user data, and we're seeing this explode in the social media world, we don't want that to happen with legal data, right, where people just lose some major legal right because they just didn't know, or they didn't understand, or they were in an extreme situation, right? So we have basic standards of protection, including on confidentiality. But it's not as broad a word as service. I don't think there's an intent to cover everything that a lawyer does as good as a lawyer does, to answer some of the first speakers. I also want to reiterate what Judge Chang said. It's throwing out legal ethics for technology companies or non-lawyers. It does put lawyers at a disadvantage, right, as a profession, but I think it's also unwise. There's a reason for those regulations. We need to give people flexibility in how they adhere to it, but there has to be some isomorphism between what the technology companies are doing and what lawyers are supposed to be doing, because there are reasons for those legal ethics rules.
Okay, to go back, are you talking about, is this a limited protection in terms, is your focus on data, information that's being provided by the client, or is it going beyond that? And that's what, I'm hearing it from people on the subcommittee, and it seems to be all or some, depending on who's speaking.
It depends. Sorry, guys.
Yeah, it depends.
Yeah. Really going for the lawyer talk now. So there's a lot of detail behind that, and unfortunately we can't condense all of that into one sentence. But we're saying that for the most part we're going beyond that because we want similar protections that the legal ethics rules provide, plus some additional protections for technology that are specific to technology. But as far as like I mean, I would just go back to the equivalent or better. I mean, that's really the core of it there.
Joanna and then Heather.
The state bar doesn't protect clients against really crappy legal services, just as a matter of how we operate. I have some concern with the way it's drafted because it lends that suggestion, but it also, there's a duty of competence in the rules, and I'm not sure how one would appropriately apply it to someone who's not a lawyer, and I think that could really open us up for a lot of challenge. Our subcommittee was suggesting that, you know, we have standards of conduct, best business practices, not applying the exact same rules, but obviously taking the rules that need to be carried over to these entities and putting those together. I just think we run into problems trying to apply these rules of ethics, all of them, without narrowing it down and making them particular, because we're going to have to add things specific to the entities as well. So let's just do their own. That would be my suggestion.
All great points. I think, in conversation, and we did all approach this one from different directions and have different things that we were bringing to it. One of the things to recognize is that when anyone, if they're online and they're purchasing the service, there's always those terms, the terms of use. Most people are not going to read them. And most of us don't read them. We just click, I agree, and we move on. And that we want to give the consumer a certain level of confidence that when they go and they purchase a product that has been certified, that there is some sort of protection, that they know that the information being provided is the most recent, that it's being kept up to date, that we do have some standards in there. And so that, when I was looking at this is where I was coming from, is that as a user, you want to know that if I'm filling out a form, case law from, 6 months ago, a year ago is being incorporated into that it's being updated and properly kept up so that you are getting the best, product that you can purchase, especially since you are utilizing it instead of a lawyer. So that's one of the things to look at as well. Can we word it differently? That I think can probably come into it, but I do feel that we need to provide the consumer with a certain level of protection, that we've looked at this and that there is somebody on the back end at the state, whoever is certifying it, making sure that there are things that they're doing so that, if they're utilizing this instead of a lawyer, they are protected in that regard. I think the other part is, as well as for, lawyers out there who are practicing in the area of law, to recognize that these products, are not going to be undercutting them in the level of law or the quality of law that they're providing, that they're still being held to a certain standard, because we know that, the lawyers out there are going to be looking at, we know lawyers out there are looking at technology products and very skeptical of their ability to deliver good legal documents out of that. And so we want to make sure that we're also providing lawyers out there with the knowledge and the security that these products aren't going to be undercutting them as well. That made sense.
Judge Chen, and then there has been expressed some level of angst about the specific wording of this particular recommendation. And so if it's okay with you, why don't we take it off the table for right now? You all can revisit it. When you've heard the concerns around the table, you can revisit it and see if you want to make some tweaks or bring it back the way it is, whatever you want to do. But I think, unfortunately, we're out of time today. And so let's pass on this one, if that's okay with you.
Fine with me. I think largely we just need a lot more detail on it. Yeah.
Okay. Tara, 30 seconds summarizing where you are with your committee.
So our committee focused on 5.4 fee sharing, and specifically we looked at ABA 2020 proposal for an amended 5.4, which looks to fee sharing with other individuals in a firm. So it's kind of a baby step to with ownership, not attorney ownership, but not quite so big where you could have investors. And not quite to the same extent that some of the other groups have talked about. And so we're going to come back with a proposal for that amendment. We've tweaked it a bit, and we'll take that up at our next meeting.
And you're meeting tomorrow.
And we're also meeting tomorrow, yeah. And in between, after tomorrow, we have a phone call, and then we'll be back in June.
Okay, We are out of time today. It was a fascinating discussion. Thank you all for all your hard work. And we look forward to seeing you in June at our next meeting, which is June 28th, I believe. And everybody take good care from now until then. Thank you.